Good morning, Ms. Rivers. Are you able to hear us?
Yes, I am. Good morning.
Great. Well, we'll get started. This is position 3 on our calendar, State versus Recchi. Ms. Recchi is here in court with her lawyer, Ms. Wood. It's 23 SC 190994. Good morning, Ms. Recchi.
Good morning.
How are you?
Fine, and you?
Okay. Sorry to see you back in those blue clothes, but we'll talk through it. I signed a probation warrant back in May of last year, so it was a while ago. You had disappeared. Your probation officer was trying to find you, and the address we had for you wasn't where you were, and the phone we were trying to reach didn't connect with you. So we're glad we caught back up with you, but we need to figure out what's next. Ms. Wood talk to me about Ms. Recchi and what you're proposing.
Yes, Judge. So we referred her to behavioral health treatment court. I have been advised by Ms. Ross that they met with her. It looks like they met with her on June the 10th. And they've accepted her. I'm just waiting on that final paperwork.
Okay.
So I've spoken with the state and probation. I think we're in agreement that BHTC is a good fit for Ms. Recchi, and that's probably the best option for her. And so that's our proposal. We would just admit to the violation. And the only thing is that we're waiting on that final paperwork. And so I'm just going to ask if we can hold the disposition or however we do it, just to make sure she's not released to the streets.
Sure. And we can talk with Ms. Simpson. There may be a way to have the revocation be released to BHTC. And then we just need to make sure if for whatever reason that falls apart, we're checking in so that Ms. Recchi's not stuck.
Yes.
It sounds like she's been accepted, and so it's very much a question of when and not if. But we can either hold off on signing something, or I think there's a way to say it's a revocation, release to BHTC, and then they'll send me or Judge Richardson an order to sign to release Ms. Recchi when BHTC can come pick her up.
Perfect.
Ms. Davis, is that consistent with what you discussed with Ms. Wood?
Yes, Judge, that is.
Okay. Ms. Recchi, tell me what you understand behavioral health treatment court to be. What do you think that is?
It's an in-house program, housing program.
So it does have some housing. The program is not where you'd be living. So you'd live in one place and they give you a MARTA card. You might take a bus or a train to get to what's called Hope Hall. That's where the classes are. But then when you're done with classes, you'd go back to the housing that they provided for you. And they'd work with you on ways to make sure you're taking medication and doing other things that'll help keep you safe and out of harm's way. Are you willing to participate in something like that?
Yes.
Okay. All right. Well, I find that you did violate your probation by not reporting and kind of disappearing. The officer couldn't find you. You want to make sure that if you do move from a place to another place, you let your probation officer know so that officer can meet with you when it's time to meet. Okay?
Okay.
Do you know where probation's office is? Because the other way you could handle this is you could always show up and say, hey, I know I've been living somewhere different, but here I am. I'm coming to the probation office.
Yes, I know where it is.
Where is it?
Up the street from the Greyhound station.
Right. Okay, good. You know where it is. So Ms. Simpson, what's the right way to structure this? Do I revoke, I don't know how long Ms. Recky's been in. How long have you been stuck in jail, Ms.? 7 months. Holy smokes.
So I was going to recommend to revoke 8 months, just to allow that last part of, to that time for BHTC to finish their paperwork.
Mhm.
We can do the release to BHT custody,
Okay.
unless you want to do it.
No, I'm okay with that, except you mentioned she's got 3 years and 2 months left. If revoking 8 months would mean subtract 8 more from that figure, we're getting close to, but that's how long BHTC takes. And especially with BHTC, where there's sometimes a few false starts, and it takes a little longer to get through the program, they are hoping that there are at least 2 years left on probation, and we wouldn't quite bump into 2 years. So maybe what I would do is revoke a couple months prospectively, but then say release to BHTC upon presentation of a transport order or something like that. Why don't we try that? Okay. Either way, Ms. Reckie, the goal is to get you to behavioral health treatment court as soon as they can get you. They need to line up that housing so you have a place to stay, and then they'll get you into the program. Any questions?
So I'll be under Walton County until they find me a bed.
Right. So
Yes, that's right. And then they'll find you a bed, you'll stay there. And if for whatever reason you walk away from where you've been staying, just plug back in with probation. If you come to probation's office, they can get you reconnected with what's going on. Or to Hope Hall, that'll really be where you'll want to go. While you are in behavioral health treatment court, probation sort of stays out of the way. They're in the background. And really your supervision comes from the people at Hope Hall. And so once you learn where that is, that's where you'd want to go if maybe you have an incident and you've left your housing and you're not quite sure what to do. Hope Hall is always a safe place to go back and say, here I am again. Okay, any questions?
Where's Hope Hall?
It's near the jail, not the city jail, but the county jail. In fact, if you look out the correct window of the jail, you can see Hope Hall. It's very near there. And that's where all your classes will be. Okay. All right. Well, if there's nothing else, that's what we'll do. And Ms. Reckie, it really should just be a number of days. It's not going to be months before you're there. It might be next week because this is a short week with the 4th of July. But I'm hopeful by next week, unless they have trouble finding a bed. That would be the only reason why it would take a little bit. Okay. All right. Well, you take care.
You too.
okay.
So what would happen if it's worded revoke 2 months?
I want to include to finish the meetings until
Yeah, to BHTC. Yeah,
Yeah, I want to include that in on that problems.
right. I don't know. I don't want to structure it so that then the sheriff would say, well, we can't release her to BHTC because she still has 27 days left. So it's revoked 2 months, reduced to time served upon release to BHTC, something like that. Why don't we try that? Any idea why Ms. Reckie was in, I mean, this warrant is old, so it's not, how did she not get on a calendar before now?
She's been on a few calendars.
Oh, your team has been looking for options for her.
Correct.
Okay, good.
Yes.
All right, because that was not Ms. Nelson-esque at all for it to be like, wait, she's been in for 7 months and
No.
she's been on several calendars as you and Ms. Ross try to, got it?
Yes.
Okay,
And there was an issue, we had BHTC go work with her and she was very confused because there was a miscommunication. So that's part of
Okay.
the delay.
got it. Okay, feel better about that. What do you want to do next?
Position 8. Lumsey Johnson. It's just going to be the bench warrant set aside here.
So Ms. Johnson, if the bench warrant is set aside, has she made bond or she has other things that will keep her in?
There's a bond.
We're just going to get out of her way.
Yes.
Okay. And our bench warrant was because we needed to have a conversation about how PTI had gone
Correct.
and maybe restructure it because PAD didn't happen or?
It doesn't sound like correct, but it sounds like there was an issue with the decab release. So I don't want to say that it's all Ms. Johnson's fault. It's a mess. There is a $20,000 bond in place on the new aggravated assault for the courts.
Right. But then I heard Ms. Davis say actually there are two cases.
Judge, I excuse the other Johnson.
Okay, got it. Okay. Good morning, Ms. Johnson.
Hey, come on.
How are you?
Oh, please don't ask you, but go ahead.
Okay, well, I won't ask that again.
It's okay, it's okay.
But Ms. Johnson, you are here on an old case you had with me, and you were given what we call pretrial intervention. You were going to be in a program with PAD, but something came up in DeKalb, and you got pulled over to DeKalb.
A little situation had went on up in Dorby, Alpharetta, and it was miscellaneous.
Okay. Well,
But she was telling me that I didn't know I had supposed to came back over here for the PAD program. So
Right.
they didn't tell me that. But go ahead.
so we'll work through that. But you did have a court date. It would have been, oops, you're not on my screen anymore. Let me get you back. You had a court date where we were going to talk about, hey, had you done PAD? What happened? And you didn't make it to court. And so one of the reasons you ended up in jail recently was a warrant that I had signed way back in 2023. And so we're going to talk today just about setting that warrant aside
Okay.
because you've got other business to deal with. You've got a new charge that won't, if that's in here, that's just by coincidence. But I do want to make sure we close the loop on, are we going to pursue the PAD situation or just let Ms. Johnson focus on the new charges? Why don't we start by talking about setting aside the bench warrant?
Yes. So Judge, way back in March of 2022, it looks like Ms. Willingham and I decided that a virtual PTI with PAD as the condition was appropriate for this case.
Yep.
Or Ms. Charles, rather. But we did the release to DeKalb, and then I think what happened was that there was some miscommunication, and DeKalb never brought her back to Fulton to go into the PAD program. And then, of course, from there, it just kind of went downhill. It's my understanding Ms. Johnson didn't have any issues with the law up until this new charge. She had been living with a family member, like I said, in South Georgia. So she has been in custody for 25 days. So
Where in South Georgia were you staying?
At my aunt's right there on offer, is it Overthorpe? Either Overthorpe or either in Albany, Georgia.
Okay, that is far south. Okay.
I think it's Overthorpe or either can't think of the other street.
Okay. But the city was Albany?
Yeah.
Okay, down in Albany. Got it. And when you have to make bond, you have bond in your new charge. If and when you post that bond, would you go back to Albany or would you be staying here in the Atlanta area?
To be honest, if I have to come back to court, I will have to stay here in Atlanta. I mean, I don't know if he will let me resign back in his establishment or not, because
Okay.
I know he have other people staying with him.
Okay, your relative down in Albany.
Well, yeah, I have a cellar brother, but see, I don't want to improve their privacy. Just like, I mean, if they have somewhere for me to go here, I will go, but the Salvation Army on not Mitchell Street, Lucky Street, they charge. I can't go back in the red, well, I call it Red October. The red Salvation Army, I can't go back in there. They discriminate on transgender.
Okay,
So what I have to do is go down to one further down and pay for it.
okay,
But I
which
don't-
means you need some money, right?
Yeah.
Okay, all right. So what are you proposing, Ms. Wood?
I'm asking the court to lift the bench warrant.
Mhm.
In the meantime, I'm going to keep talking with Miss Davis, probably Miss Ross as well. Miss Davis had mentioned possible global resolution for both cases. I would just need some more time to finesse those details with Miss Johnson.
Okay. I guess that would be a way to get Ms. Johnson's new charge here. If it's an accusation, then it can be green sheeted here and handle it that way.
Yes, Judge.
Okay. All right. Ms. Davis, anything you want to add to the situation?
No, Judge.
Okay. If the goal is to resolve both, why shouldn't I just leave the bench warrant in place so that everyone has a chance to meaningfully interact with Ms. Johnson, your staff, et cetera?
That's a possibility, Judge.
Okay. If it looks like there's not going to be a global resolution, and it looks like Ms. Johnson could post the bond in the other case, either because she can or it gets reduced to a level that she can, then I'm happy revisiting the question of the warrant. But in the meantime, I think it helps keep everyone connected.
Understood.
Okay. So Ms. Johnson, you will get a visit soon, if you haven't already, from probably someone named Ms. Ross, but it's a colleague of Ms. Woods, who would talk with you about options for, like you were saying, a place like Salvation Army, but maybe one where they don't discriminate and maybe they don't charge. That would be a better fit. I don't know that that place exists, but Ms. Ross would know. And so she'll talk with you about your needs and your concerns. Ms. Wool will talk to you about your other case, because of course you've got these two different criminal charges. One in my courtroom from way back in 21, that really hasn't gone away. They basically put it on a shelf with the.
Which one is that one, if you don't mind, Your Honor?
I don't mind. So I'm not going to be able to describe it better than telling you what the charge is.
Okay.
And maybe that'll help you recollect. But the allegation is that in June of 21, so that's 4 years ago, you assaulted someone named Alice Wade. That's the allegation. And that's the one where, with your lawyer's help, the agreement was you'll go to PAD.
The same one that I got into it with?
Most recently, I don't know your recent charge is coincidentally from June of this year. So June is a complicated month for you, but you were, what it shows in the system is that you were arrested a few weeks ago for a different aggravated assault. I don't have any. Well,
This is my first arrest here.
okay.
What do you mean?
Well, let me see if I can find it. But while I'm looking for that, just to clear things up, it sounds like the goal would be to resolve both that old case I mentioned with Ms. Alice Wood and the newer charge, which, here's the number, 4522.
Excuse me.
So you were arrested on June 7th, so just about 3 weeks ago. This year, and the allegation is that you assaulted someone named William Gordner with a hammer.
Okay.
And I don't want you to talk about it because there may be all sorts of reasons why you'd say that didn't happen, but that's the allegation, is that you and Mr. Gordner got into it, and he had some cuts on his head, and you had a hammer. So you were arrested for that. When you got arrested, they said, oh, wait, Ms. Johnson has this old case with Judge McBurney, and Judge McBurney had signed a warrant because you never ended up doing the PAD situation.
What's that you came in there the first time? Where did she go? It was you.
We've visited at the jail.
No, 3 of y'all came.
See, that's how much they care.
The
They're bringing a big
The person
team.
came and told me that I had a old, A bench warrant.
Yep.
From DeKalb County.
Oh, I don't know about the cab, but you had a bench warrant from me. That's where I signed
From where?
for the case with Alice Wood and Alice Wade, who you hit with wood, it says. Anyway,
Oh, you talking about in Colorado?
nope, I'm talking about, I don't know
You say
anything.
hit with a stick?
Yeah. Well, it says wooden object, and then it says 2x4. But again, I
I was
don't.
in Colorado. I suppose I already had done settled that up there.
Okay.
That
Well,
was stealing my personal and jumped on me and stole my pad and pocketbook.
well, they shouldn't do that. But this is a different situation. This is
Okay,
not
but instead of
Colorado.
one of the,
What we do?
he must have put it in the computer. One of the, used to be a correction out here years ago, but now he's up there in Colorado.
How did you get all the way to Colorado?
Huh?
How
It's
did
been
you-
away from a whole bunch of drama, and then they got, went up there for shelter, because they don't have too many shelters here.
No, but Colorado's far away.
Yeah, I think it's 3 or 4 states away.
So the case here, the one that you had the bench
I don't
warrant
remember
for,
nobody here with no stick.
the allegation is that you were up near Haynesbridge Road and you were swinging something at pedestrians, and the officer,
Where is that road is?
it's in probably Alpharetta. It's in Alpharetta. Anyway, different situation, not the Colorado one. And Ms. Wood and others are going to talk.
No, excuse me, they locked me up for, it's called a conduct.
Okay.
But that's when the officer came over to me and slammed my head almost into the back of this person's black car, and I turned around and asked him, why did you do that? He
Okay.
claimed that I was harassing the people who were around where I were.
Okay. That may be
That's
this.
when I went shot to you guys, but I already had something going on in the cab.
Yes, yes. So we're connecting now. And it was that
Right.
DeKalb
And see,
situation.
what I did, I ended up doing a year in Rice, and I kept telling them.
You did 405 days. You were there
did
for a long
whole
time.
Year.
Yeah.
And then when it was time for me to go to the Cab County, so when I got over there and I walked in, and she said, you should, and I had the paper to bring it, and they detailed it. Cause I couldn't come there to come here.
Yep. Well, my hope is that you and your lawyers, your legal team are able
Well,
to.
evidently, my legal team is not really for me, Your Honor, because I want to keep going through this.
Well, except that you didn't come back to court. That's not
But
your
see,
legal
they didn't
team's
tell
fault.
me I had to come back to court.
And one more thing, and then we don't need to have a back and forth. Your legal
Okay.
team didn't have anything to do with this poor guy getting hit in the head with a hammer.
Correct. But
Okay.
see, you don't know what the poor guy did to me.
I don't.
Me and her already have been through this situation.
I'm-
It's the same guy.
I'm not-
It's the same guy.
I'm not taking
Go ahead.
sides. He may have done some real bad things. You're the one who got arrested for it.
Correct.
And so here we are.
And they didn't see what they threw at me behind the motor station, which I
Okay.
got up and moved, as I was telling the first lady. But go ahead.
Okay. So I hope to see you again soon to have a conversation about maybe resolving both these situations.
Okay.
And connecting you with some resources that help you out so that you aren't having to bounce from place to place. Okay.
Okay, so I'm not trying to rush you. You know how long that would be? Or I have to spend months and months and
It's not months and months, but I do need you to speak with Ms. Ross, who will come talk to you. It's another part. She's not here right now. She's got other stuff going on, just like you. So she'll come visit with you. And then, once your legal team has figured out a plan, they'll talk about it with the prosecutor. If they can get pretty close to agreeing, we'll come in here and see what we can do.
Okay.
All right. So your best bet is to just keep your head down and do your best to not get into it with anyone while you're at
And
Rice
that's the
Street.
reason I asked before it got started, Your Honor, to move me to another situation. And she told him, but he never did it. So that's why I stayed in the park. But I don't mind sitting in the park. I just open the door so it won't fill up with that smell of metal. I can't take metal like that.
Okay.
And it comes and shut and slams the door. I mean, Long as you don't say anything to me or do anything to me, I'm basically fine.
Good. Well, hopefully that's how it stays, and I hope to see you
And
soon.
another thing, like I said, I don't know how long this is gonna take. I really wanted a pad or something to listen to. I don't know why, Your Honor, and I brought it to your attention last time, you and the other. Why do every time I get locked up, they take my bank card?
How do you have a bank card?
I'm saying they takes it.
Okay.
Usually when we get locked up, we got their answer that we want commissary.
Yeah.
We're taking a swipe. Every time I get locked up, they takes my bank card and don't
Okay.
get it back.
Well, I think they take everyone's, but they should give you your stuff back. And your lawyer can help you navigate that process. When you are getting checked out, they can do their best to make sure that what you had when you got checked in is given back to you. Okay?
No, I was saying every time I get arrested, I want to slide my card to get commissary.
Okay.
So y'all don't do that anymore.
I don't think so, but I don't know. I don't know a whole lot about how that works.
Okay.
I think people put it on your books for you, but the great person to ask would be some of the folks who are helping you here or out at the jail. Okay?
Mhm.
All right. Thank you, everyone.
Thank you, Judge.
Walk on.
So Ms. Wood, so that Ms. Johnson doesn't languish longer than necessary, what's the right next step? An inquiry calendar in 30 days?
Please.
Okay, and we can always meet sooner if things develop, but 30-ish days, is that enough or should I do more?
That's good, Judge. I'm gonna check because Pat is usually really good about reconnecting. I have a feeling they have no idea that Monty is back in Fulton.
I bet that's right, or that was really, I mean, that was so long ago that
Right.
Ms. Johnson was even on their radar in 2022. So it sounds like it was the DeKalb hold that blew everything up. It's not DeKalb's fault, but Ms. Johnson had to get over there, and then the things that were supposed to happen didn't happen. Okay. Next.
Judge, so I have an announcement on positions 5 and 6. Mr. Johnson.
Okay. Let me find his warrants. You good? Ish? So Mr. Johnson is a failure, he's a technical violations. No, there's more developments?
Some more, Judge.
Okay.
So.
Oh, this is someone with 2 cases. You were saying Johnson has 2 cases and, oh, that was missed. Okay.
Okay.
And Johnson does have 2 cases.
That's not Miss Johnson.
Yeah.
He has an indicted case and then a new unindicted plea. And he also has 2 separate private attorneys involved.
Oh, so Miss Simpson, these didn't go to, I guess I have a couple questions. Why wouldn't this be a Friday calendar situation for Mr. Johnson?
The riot case is not a premise for the warrant because it actually took place while he was waiting to go to court on.
So I don't mean the new charges. So first of all, I just have 2 warrants that reflect
Yeah, they're saying.
the technicals. And so those seem like they ought to be on the Friday calendars for Judge Mao or Judge Brooks. Okay, but we now have 2 new felony cases. One's been indicted. So it seems like there ought to be a petition and warrant that reflects.
Well, the petition, the plea I did not know about because it did not come up anywhere in my research.
What's the indicted case?
Right in the institution, he got into a fight in the jail.
Okay.
But that took place while he was waiting to come to court on these two cases that he's on probation for.
Oh, so it's an old riot in the jail. Okay, got it. And so that wouldn't be a violation of probation. But this newest thing,
That one, I don't know, I don't know if this officer was aware about it.
okay,
So that's the only reason why I couldn't even, I would have, but that fleeing charge was not brought to my attention.
let me look at one thing. So Ms. Hill, who is a quasi colleague of yours, filed a conflict in this case. Not as in I cannot represent him, but I cannot be here. So did she originally?
She was here.
Oh, she was here and then left. Okay.
I believe she handled the pleas on these a while back,
Okay.
and then there is, so the newly indicted case is assigned to Judge Williams. It has plea arraignment coming up on the 16th, and it has a private attorney, I believe it might be a C3 possibly. Since
Okay.
the local code for this.
Got it. So under the new instructions to the litigation managers who put together the calendars for the Friday revocation, this would come here because family violence intervention was a special condition and he allegedly didn't do FFIP. And violations of special conditions are supposed to go back to the sentencing judge or the judge who has the newly indicted case, but only if that was part of the violation, which it wasn't. So he's in the right space. Do we want to handle these now, or is he not going anywhere because of these other cases? In which case, we wait. There will be at least one more petition, it seems like, based on the newest charges.
If either in this case can send me that information, I will probably answer.
I can give you the PI number. 25 PI 003319. Uh-huh. So, my thought would be to, well, what did you and Mr. Johnson talked about?
Well, I haven't spoken to him now that I know that Ms. Hill's plugged back in.
Oh,
It
right,
just seems
temporarily.
messy.
Yeah.
There's multiple other attorneys.
Yeah, and if she was here, then we ought to sit tight on that one. Maybe Ms. Nelson can reach her to see if she's coming back this morning. I mean, she may have just gone to another courtroom. How did you know?
Yeah, I know her face.
Okay. The case with Judge Williams is moving in its own orbit because it predates this stuff. Okay. All right. Can you at least start in motion whatever it takes to get a petition for the new charges. If Ms. Hill comes back, she may say, look, I'll talk to him and we'll just resolve everything. But if she doesn't, then we'd reset it for her to be here anyway. And if we could get Ms. Hill here and a new petition, and we could handle it all. How much time is left?
He's got 1 year, 10 months, and 26 days on both cases.
Okay. Okay. What are we gonna do next?
I have Mr. Thomas, you want to do number 4?
I want to do whatever we can move along.
I'm just having a council with Ms. McBurrows.
Let's do that.
I'm not sure what the
Position 7.
Yeah, no, I've got it, and I have her warrant. Is it hard to read?
Yeah.
Okay. What is your announcement on Ms. McBurrows?
Well, Judge, she has been on probation before the court since 2023. She's on the first offender probation. Late last year, I believe she got 3 new separate warrants out of 3 different jurisdictions. Cobb County, Gwinnett County, and DeKalb County.
Right, that's the basis for the revocation.
Yes, sir.
Do you want her out here while we talk, or you've already talked with her?
I've spoken with her.
Okay.
So essentially probation is asking for a revocation of 2 years. Is she there at the door? Could she come out so she can at least hear my?
Yeah, Ms. McBurrows? Great, she can come on out.
So we've spoken to probation. They were willing to revoke 2 years to serve and not do an adjudication because she hasn't been convicted of any of these new charges. I've spoken to Ms. McBurrows. She is 3 months pregnant. She has a 5-year-old autistic child. She's just not in a position where she can risk 2 years of confinement, consider her current situation. She's given me a witness that would impact the Gwinnett and the Cobb County case that I think would be in my best interest to at least, or her best interest to speak to an interview. So we're asking the court to either schedule it for evidentiary hearing so I can get that witness produced and maybe, or at least advise the state of what that witness would testify to. And then maybe we'd be in a better position to resolve it.
Okay, that's a reasonable request.
The cab case is listed as a felony, but we believe it actually is a misdemeanor as well. It's listed as a burglary charge, but it sounds like at the preliminary hearing, somehow it should have been a theft by taking, but it was bound over as a burglary.
Okay, so DeKalb is burglary or theft by taking, Gwinnett is shoplifting, and Cobb is
Marijuana,
and false name.
yes,
Okay, on Christmas Day.
yes.
Okay, all right. Who is taking care of your son right now?
My daughter and my father right now, but he works also.
How old is your daughter?
He's 5.
Well, who's taking care of the 5-year-old is what he's
It's
asking.
my dad.
Oh, I thought that 5-year-old was a boy. How many kids do you have?
No, it's a girl.
It's a girl. Okay, so who's taking care of your daughter?
My dad.
Your dad. Okay, but you're saying he works.
Yes, he does work.
So when he's working, where's your daughter?
He has to pay for.
Daycare?
Yeah,
Okay. What does your dad do?
he drives trucks.
When he's working, is he like driving to California and gone for a bunch of days, or is he local?
He's local right now, but usually his routes are out of town. But considering the circumstances, he's
Okay.
local right now.
How long have you been in jail?
Almost 30 days.
Okay. Well, we can reset this so you can talk with the witness, or try to find the witness, and then obviously circle back with Ms. Davis. And then Ms. Davis we'll reset it for an evidentiary hearing. Doesn't mean that's how it has to play out, but Ms. Davis will need to get whomever. And she can try to prove up all three cases, really only needs to prove up one. So she may work with you. If this witness addresses a couple of them, then there may be one where people admit to it and we work through it that way. But just certainly stay in touch with Ms. Davis so she's not bringing in people she doesn't need to bring in.
Yes, sir.
And I'm sure you will if this witness is in any way exonerative, if that's a word, that's someone that Ms. Davis will want to talk to. So Ms. McBurrows, we're not going forward today with this because there was either you admit to it and there's a pretty stiff recommendation from probation that seems pretty reasonable given this flurry of activity at the end of last year. But it sounds like there may be some more to the story that would explain what was going on at the end of the last year. So I'm going to let your lawyer work through that, and then we'll come back in about a month to see if the evidence has changed or how we're going to work this out has changed. If there's not an agreement, then we sort of have a mini trial. There's no jury in here, but the state would have to bring in a witness or witnesses to say, on this day, here's what happened. And Ms. McBurrows had marijuana and said her name was Frida. And on this day, she was caught leaving the Walmart with this in her pocket or something. I don't know what the allegations are, but they'd need to prove it up like at a trial, just with a lower burden of proof. And your lawyer would be able to cross-examine, and your lawyer could call a witness. It sounds like there's someone out there who maybe can explain some of this in a way that makes it seem not quite as serious as it looks on paper. Okay? Any questions about any of that?
You have a question for me? You did ask.
Yes.
What?
So,
She's asking if there was any consideration for the court for her to be released in the pendency of this. I talked to her in the back. I'm not sure if the court would do it under house arrest or if you just would keep her in custody. She is, as I understand, 3 months pregnant, but I'm not sure what the court's consideration is under that position.
So my thought, Ms. McBurrows, given the number of allegations in the warrant, is that I'm going to keep you where you are. But know that your lawyer will work hard and quickly on your behalf, and the state will be ready to go for our next hearing. So I'm going to decline your invitation to have you be out, whether it's on house arrest or whatever. We need to work through this and figure out what's next for you, and not run the risk that something like these allegations pops up again while you're out, because that would just make it more complicated. Okay? Thank you.
Thank you, Judge. May I be excused?
You bet. Ms. Mignot is listed as counsel of record. Did you file an entry? I just want to make sure you get notice.
We did. We filed an entry. We filed a substitution of counsel sometime last week, I believe, because her office reached out to us and said that they were getting notices along with us, but we did get notices as well.
Oh, you're in now. The calendar was published a while ago, and so, but it now says Robert L. Booker, so we're good.
Okay.
Excellent. So you'll get notice of when we're reconvening, and we'll see if we can sort this out then.
Thank you, Judge.
Okay. All right.
Thanks.
So Ms. Rios, you were ready to talk about Mr. Thomas?
Yes.
Okay.
That is probation revocation, and he also has a, with another case.
Yeah, he's got a prohibition case. So why don't you repeat that?
No, but, for the revocation, we're gonna revoke him on more than one. You said there was a pending
Yeah,
warrant.
yeah, he's got another probation case. Thank you.
Sure. What are those other case numbers?
14 SC 12830. And the other one is 22 SC 182-423. I think they were Judge Woodward's.
Oh, I'm next to you. Okay.
On everything, so you don't have to come back and do. She looked up and saw that you were in the county, so we're just trying to do credit for times. But it's still the judge's decision.
Yes.
All right, let's go on the record in Mr. Thomas's cases. On the calendar is 23 SC 190768. Good morning, Mr. Thomas.
Come on, sir.
How are you?
All right, sir.
Good. You're here in court with your lawyer, Ms. Rios. We have Ms. Davis for the state. Mr. Thomas, you actually have two other cases for which you are on probation. One of them is 14 SC 128530. That's a burglary from 10 years ago with Judge Newkirk, and he sentenced you to 15 years to serve 7 with the balance on probation, and you are still on probation in that case. Ms. Simpson, how much time is left on that case?
3 years, 8 months left.
And Mr. Thomas, you also have 22 SC 182423, which was a case with Judge Whitaker. Gosh, you've had revocations in all these cases, several. And with Judge Whitaker, you pled to some things and got 5 years to serve 1 with the balance probated. So that was 4 years of probation. How much is left on that one?
4 months, 28 days.
Okay. And then to complete his tour, you were in front of me on that 23 SC case that I just mentioned, which was drugs and false statement. Mr. Wright represented you. How much time is left on that one?
3 years, 1 month, 6 days.
All right, so you got 3 open cases. The allegation in the latest warrant is that in November of last year, you were arrested for October of last year, you were arrested for having illegal drugs. You got a very small bond, and then you were released. And you've tested positive for a bunch of different drugs since you started treatment, and then you missed some drug screens. So a couple of technical violations, and then a more serious one, the new arrest, which I think is an unindicted case at this time.
Yes, Your Honor.
Okay. Ms. Rios, what is Mr. Thomas admitting to the arrest and the technicals, or what's our posture?
Yes, we're stipulating to that. And I've talked to Ms. Simpson, and we agreed to revoke 6 months. He's been in Rockdale County. He got in December 2024, and then he was moved to Rice Street on April. He has 4 children, 2 17-year-olds, 11-year-old, and a 2-year-old. He was working for a city in parks and recs, cleaning up parks, and he believes that he would be able to, once he's done with everything, return to that.
City as in City of Atlanta?
Yes.
Okay. What about getting Mr. Thomas some help? He was supposed to do RSAT through Judge Newkirk's sentence.
So I did refer him to drug court. They did not accept him. They said from like 2004, something, a long time ago, they said something happened, or I guess he didn't complete something, and so he couldn't go back. And then the RSAC also, I guess
He was at the NADRC and, this testing positive plus the charges would got him terminated. But I spoke with the chief over there and she said he couldn't come back.
Could not? Could not. Okay. Did you do RSAT when you went down the road for a while with Judge Newkirk's case?
Did RSAT my last 6 months.
When you were with the Department of Corrections? Okay. RSAT's usually longer than 6 months. That's just, you did 6 months and then you paroled out?
Yes, sir.
Okay. All right. Oop, there's that door. So you got revoked for 4 months by Judge DeFore in August of 23 for failing to report and paying restitution. Then in May of 24, you were I don't know how long you had been in. You basically got credit for time served, and then you were supposed to do MADRC, and you had new charges. Okay. All right. Ms. Davis, what is the state's perspective on Mr. Thomas's situation?
Judge, we had hoped to maybe resolve some of the other open cases. I believe just the petition has listed the 24 PI case, but there is a 25 SC case that is in before Judge Schwall.
Oh, what's that case?
25 SC 001399. I believe it's a firearm by felon. And some other charges.
Hold on one sec. It got transferred to him because Mr. Thomas also has an open case from 2007 with Judge Schwall. That's an old case. How old are you?
35, sir.
Okay. All right, so we've got this newer case with Judge Schwall that is based on some old facts, though. Mr. Thomas allegedly had the gun in November of 23, so new indictment, but that's old conduct.
And I was initially, when I thought he was going to be able to do drug court, I was going to say that we could resolve everything in drug court, but since he couldn't do that, I thought it would be better just to handle this and let everything else go to Schwall.
Yep. Okay. I'm fine with that plan. Things going to Schwall. Okay. Let me check one more thing. Okay, I can listen. You were in the middle of something, Ms. Davis, when you said, "Oh, by the way, he has a new indictment," and I just needed to see that.
Yes, well, with that caveat, if those new cases do go to Judge Wall, that I think 6 months would be appropriate just to resolve, I guess, these 3 series of probation cases. But if it somehow boomerangs back, probably best to.
Well, the new case is staying with Judge Swall, because it went there because of the very, very old case, the '07 case. And it's conduct that wouldn't be a basis to revoke in what I'm gonna call our case, the case here. It would be a basis to revoke in the old Newkirk case, because that's from 2014, but that's not before us today. So we're dealing with a new arrest, new-ish arrest, and then continuing to use. There really isn't a treatment option because drug court said no. MADRC was a crash and burn.
The chief over at MADRC suggested, he could go to PDC, which automatically he's eligible, but with our programs, you can't have any outstanding charges.
Yeah, right. You'd be stuck here, not able to go in.
If that's just something they can do on the new cases and just have because I already have my social worker involved when we're looking at our options, and maybe we can just like whoever's in Schwal.
Lead to the PDC, has enough time. So if that option.
Meaning in the Judge Schwal case, he could plead, yeah, I'm gonna leave that in his capable hands and the legal team there. We could at least close out this situation. Your 17-year-olds, are they in high school or what are they up to?
You working this summer, sir? Yeah.
What are they doing?
One work at Chick-fil-A and the other work at a restaurant washing dishes.
Okay. Are they gonna be seniors in high school this fall?
Yes, sir.
Do they live in the same household?
Yes, sir.
Where do they go to high school?
Maine Jackson.
Okay. And when you're not locked up, are you in that household as well, or they live in a different house?
I stay in the same household, sir.
Okay. And what about the 2 younger ones?
I'm stay with their mother.
Okay. So you and the mother of the 7, are they twins?
They like one of my baby mother. She was arrested, so she gave custody to the other one.
Okay. The 17-year-olds, they have different moms,
Yeah,
but they stay with you and then one of the mothers.
my mother.
Oh, your mother.
Yes, sir.
Got it. So that's who they're with now. Okay. So what you're saying, Ms. Rios, I've got Mr. Thomas as having been in custody with us for 2 months.
Yes.
But he was in Rockdale before then?
Yes, and Ms. Simpson was able to confirm that.
What?
I thought he was arrested on this warrant and they took him into custody, but I think you might have other stuff.
In Rockdale, okay, because he wouldn't have been stuck in Rockdale for that long if all it was this. Okay. All right, Mr. Thomas, you are wrestling with something. I don't know if it's addiction or the other things going on, but you keep getting in trouble for having things you know you're not supposed to have. It disrupts your life. It makes it hard to hold down a job. It's got to be terrible for these kids who is dad here, dad not here. I mean, you just can't be a particularly reliable guy in their lives, and that's sad. And I would hope that would motivate you to try to get some treatment. I'm well aware that you don't just wake up one morning and say, hey, I don't have an urge to use. That's not how it works. You have to invest in recovery and stick with it. But you've been given opportunities to do that, and they didn't work out, and that's frustrating. I can't speak for drug court. I don't know why they said no, but I trust they had a good reason for that. But you may need to seek out resources to help you with your addiction, because it just drives you back into a ditch each time, and it's not going to get better if you don't get help. All right. So, Mr. Thomas, I find that you did violate the terms and conditions of your probation by getting arrested in October of last year for possessing drugs and for multiple positive tests for a whole bunch of different drugs, and for missing your drug screens. I will revoke 10 months of your probation. You will get credit from the time you went into custody in Rockdale. We'll need to get that date. I will then reinstate the balance in the 23 SC case, as well as the 22 SC case, but I will close out, terminate probation in the 14 SC case, so you don't need to have that following you around anymore. When you are back on probation, you are going to need to take at least 3 random drug screens a month with probation. I can't make you get treatment. We have offered up to you the kinds of treatment that can be mandated, and those didn't stick. So I encourage you to do what you can to get help for what you're working through. And then you're going to be in front of Judge Schwall for the real old case from '07. And it's a new indictment. It's old stuff. You allegedly had a gun back in 23 or whatever the indictment said. And you'll work through that with Judge Schwall. Ms. Rios, anything else on behalf of Mr. Thomas?
I'm so sorry. I'm still confused about the revocation, the credit thing. And so, because I thought it was under 6 months they would get credit, but over 6 months they wouldn't get credit.
So my understanding is that I'm not remembering what the cutoff is for when they go into the Department of Corrections versus they stay here.
I thought it was 6 months. Do you remember?
According to, if it's going to Department of Corrections, anything over 6 months, they do not get credit
Right.
in regards to verification.
So would it be?
Got it. So it would be, but I don't know, do they go to the Department of Corrections for sentences that are more than 6 months, or is it, I thought it was 12 months?
That part, we're still a little.
It's, yeah.
Those particular type cases, y'all just get up on the decision on custodian.
Okay. Got it. Then how about this? I'm going to revoke 4 months starting today.
Thank you.
So you don't get credit for the time you served, but that gets you to the 10 months.
You understand everything? Okay. Thank you, Your Honor.
You're welcome. All right. I don't have an update on Ms. Hill, but we have Ms. Rockwell's here. Do you want to do Mr. Hayes now? Okay. Did Mr. Greenway ever show up? Hey, he's here. All right. Let's hold off on Mr. Hayes for 1 sec. You can come on up. Mr. Greenway, how are you, sir? Good. So when we were last together, we learned that you can come on up to the podium, please. We learned that you made too much money to qualify for appointed counsel. And you said, gosh, I don't feel like I'm super rich. And I said, I'm not super rich either, but I'd have to find my own lawyer. So that's how we left things.
All right. 14A District Court for County of Washington, State of Michigan, is now in session. All those having been for the court draw near, the Honorable Judge Simpson.
You may be seated. Arbor Manor versus Patrick Brooks.
Morning, Your Honor. Paul Hughes, P 31986, appearing on behalf of the plaintiff. My client is in the courtroom as well. Today is the scheduled date for trial.
Patrick Brooks. Being no response, you'd raise your right hand, take it to call. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, help you God?
I do.
All right, go ahead. What is
Your Honor, plaintiff requests a default judgment for possession only. The amount of rent due is $3,639. That includes July's rent, $175 in court costs, for a total amount due of $3,814. We would ask that default judgment be entered, requiring the payment within 10 days, or writ to issue. Partial payment shall not stay the issuance of the writ. There's no money judgment at this time.
judgment to the plaintiff? That is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
Thank you, Your Honor.
Thank you,
I'll
sir.
submit the judgment by email.
That'll work.
Thank you.
That'll work. Sorry about the delay, sir.
Thank you. Have a good week.
You too. This is whatever. Patrick Tatora versus Martin Youngs.
Do you need to see?
No, he won't be staying long.
I hope that's the case, Judge.
Me too.
Good morning, Your Honor. May it please the court, Eric with FP 65354 on behalf of plaintiffs.
Good morning, Darwin Fair, defendant P number 31266.
The plaintiff filed a motion to lift the stay and enter an order of eviction. At the time, I had not received a response, but I thought I wasn't sure where other proceedings were. I realized what was represented in the motion. And so I set this for hearing. So.
Well, Judge, I hope we would not be here today. we've been down this road a number of times. And your question is always the same question, and the answer is always the same answer, which is the Wayne County Circuit Court has not closed the file. There's still pending actions in front of the Wayne County Circuit Court that impact on the issue that's before this court. So unless we're here to argue the Wayne County Circuit Court motion, I don't know what more to say to the judge. There's really nothing more to say.
This property is located in Washtenaw County, however.
Where's the?
Yes, yes, it is, Your Honor.
Yeah,
Yes.
the property's in Washtenaw, so I'm not clear why I'm worried about anything being litigated in Wayne County.
Well, what happened?
Let me rephrase that. I don't know why I would be worried about that with reference to this action proceeding forth in the eviction happening.
Well, the reason, Judge, is for the same reasons that occurred multiple times before this court, which is the property in Washtenaw County is subject to a settlement agreement that was entered into with the Wayne County Circuit Court judge. So this is part and parcel of this global settlement. And the reality of it is that this case on this property is still subject to the jurisdiction of the Wayne County Circuit Court judge, as has been the case every time we get before this court. As every time we get before this court, it's the same issue, Judge. And now this is, I will admit, this is the first time I've heard the court say this, but the reality is still the reality. This property is part of, and Judge, I know you do not want me to repeat myself, and I don't like to repeat myself, but I'm a little concerned that if this is not being gotten across, is every time we get to come to court, it's because of the same issues of this global settlement that is before the Wayne County Circuit Court judge.
Well, no. Before I would, right. I mean, the reason the case is here is for whatever its reasons. But part of the reason that things were stayed is because clearly it was headed up the chain, the appellate chain. My understanding is that's no longer the case.
No. And let me.
No, that's
not the case. And so let me explain it this way, Judge, because I'm trying to get into your head. What the court, I think, is concerned about is the Washtenaw County Circuit Court case that directly impact this case. And that case, the Washtenaw County Circuit Court case, which was appealed to the Michigan Court of Appeals.
Right.
Okay, that case was dismissed, Judge, as a result of a global settlement that is before the Wayne County Circuit Court judge. So what happens in this case is still being handled by the Wayne County Circuit Court judge because the Washtenaw County case, which was appealed to the Michigan Court of Appeals, was voluntarily dismissed as a result of the settlement.
Let me cut to the chase. Why wouldn't I just lift my stay, issue the order of eviction, allow it to be executed at some future time, that they couldn't do it right away? Allow it to be executed at some future time. And if you're correct, then get a stay from Wayne County.
Okay, well, Judge, okay, now, and I'm hearing you, and I'll walk down that road with you. So the issue of the quote unquote eviction is a function of the ownership of the subject property. The ownership of the subject property is specifically before the Wayne County Circuit Court judge. So let's assume that the court says, okay, I mean, enough's enough, although it's the same issue that has been before this court multiple times, and the court says the same thing multiple times, which is, I'm not going to do anything until the Wayne County Circuit Court has made a decision, which is what, okay.
I don't know that I said anything about Wayne County.
No,
I think I said something about Washtenaw County and the
No.
Court of Appeals and the Supreme Court.
no, no.
Go ahead.
No. It's never about the Washtenaw County. It's always about Wayne County. It's always about Wayne County. It's never about Washtenaw County. Because Washtenaw County, Judge, again, was appealed to the Michigan Court of Appeals. It was voluntarily dismissed as a result of the global settlement that was before Wayne County Circuit Court. Judge.
And Mr. Fair, I'm saying, let's assume for the sake of argument that you're correct. I have a feeling there's going to be disagreement as to what you're saying in part. But why then wouldn't I just grant the relief, issue the order, and then you get a stay of that and allow an opportunity, so I wouldn't have it where it could be executed immediately, give you an opportunity to then get before the Wayne County Circuit Court, which you're saying this property is part of some global settlement, and allow that court to basically stay any order of eviction or enjoin the plaintiffs in this case from moving forward.
Okay, Judge, allow me to walk down that road. Okay, so
why is that a hard question? I don't need to be walked down the road. Why is that a difficult question to answer?
because the hearing, no. Because the hearing that you're making reference to, that I should go before the Wayne County Circuit Court judge and ask for a stay, is a hearing that is essentially scheduled for July the 18th. That hearing will address the very point this court is making. So
then why don't I grant the relief, indicate that the writ cannot be executed until, if your hearing's on the 28th of July,
no, 18th. I'm sorry.
that it can't be executed until the 28th of July, giving the 10-day statutory period from the time of that hearing.
Okay, Judge, this is the road we always walk down, because what happens is on the 18th, we don't know what Judge Ewell will do. Judge Ewell may say, I'm not going to hear it on the 18th. Or, and Judge, I'm only going by what happened in the past, and the same.
You're gonna have to leave. You're gonna have to leave.
I do not want to argue, Judge.
Go ahead.
Case. So what has happened in the past, which is probably what's going to happen today, is that on the 18th, Judge Ewell will do one of two things, which has happened in the past. When this issue is before this court, Judge Ewell may or may not hear the case on the 18th, or may hear the case on the 18th and then decide not to make a decision until sometime in the future. Now, again, Judge, I'm not saying this for the first time. This has been the history of this case. Now, if we look at what happened, they filed a motion to go before the Wayne County Circuit Court judge, and it was scheduled for the following Friday. At the same time, they filed this motion in front of you and filed a motion in front of the 35th District Court, assuming that the Wayne County Circuit Court judge would close the file. Because I will tell you, Judge, the question that you always ask, this is the question you always ask: what's the status of the Wayne County Circuit Court case? Is it open or is it closed? The answer is always the same. It's open. Your response is always the same. Well, I'm not going to do anything until the Wayne County Circuit Court makes a decision. And then a couple of times, Judge, you said, I'm going to adjourn it to right after when the circuit court judge makes a decision.
So why don't I put an end to that and just grant their relief?
Well, because
it doesn't leave you, Mr. Fair, without remedy, because you can always ask the Wayne County Circuit Court, as I've said, to either stay that writ if they've taken some jurisdiction over this property, or to enjoin the defendants from proceeding on the writ that I would issue.
Well, Judge, this is a conversation we've had at nauseam all the time. And
well, I'm trying to end it.
And what I think but I think, Judge, what you recognize is, well, that means I've got to run to the Wayne County Circuit, Wayne County Circuit Court, ask for a stay. The judge is going to say, aren't we going to be hearing this on the 18th? And then on the 18th, like what has happened in the past.
Well, hold on a second. No, you wouldn't have to do that if you would listen to what I'm saying. What I'm saying is I could grant the plaintiff's relief. They could not do anything, and I'm not even saying on the 18th. I'm saying for a 10-day period after that hearing. So if the judge at that point in Wayne County doesn't do anything, the 10-day statutory period would begin to run on the writ.
Wait a minute, if he, wait, Judge, okay, so the motion that is before the Wayne County Circuit Court, which plaintiff acknowledges affects what this court can do. What they're asking the Wayne County Circuit Court is close the case, close it. And then if it's closed, then they can come to you and say, hey, Judge, it's closed. So let's go back to that point. On the 18th, if the judge does not close it, if the judge does what he has done in the past.
If judge does not close it, you could request of the judge to enjoin the plaintiffs from proceeding forward. If the judge does close it, the writ would proceed.
Well,
that seems really simple to me.
The 10 days after that.
Right, 10 days after.
But that means a couple things. Number one, if I'm hearing the court is saying, well, if it gets adjourned to August the 10th, August the 18th, another month. And if at that time, the judge closes it, that means in this interim period between July the 18th and August the 18th, by definition, they can't do anything.
No. I'm not saying that.
Okay.
What I'm saying is, you're saying the Wayne County Circuit Court has that this is part of some global resolution.
Correct.
Okay, I'll take you at your word for that. I've not seen the resolution. That's fine. It doesn't matter to me. What I am saying is, I will assume you to be correct. I will assume also that Judge Ewell will act within his authority regarding any agreement there is. Right?
Correct.
So if I grant the plaintiff's relief, built into that are enough protections for the defendant in terms of being able to request of Judge Ewell to enjoin the plaintiffs from acting. If that case is going to be adjourned out, or he doesn't rule on that day.
No. Well, okay, Judge. And I'm not going to belabor the point. I'm going to put the past in the past, because we've always in this situation, and your position is real simple. Is it open or closed? If it's closed, if it's open.
No. The question is it pending or not?
Okay.
So if the issue, Mr. Freeman, if the issue before this court is pending somewhere elsewhere.
Correct.
That is always what I will address.
Correct.
And I think properly so. It doesn't sound like that's what's happening here. It sounds to me, based upon what you're saying, and again, I haven't seen it, that there is some resolution of this global resolution, whatever it is. I'm saying, fine. There are still issues to be decided with that. They don't need to be decided here. And so that I could grant the relief that the plaintiff requests with enough safeguards that protect the defendant until whatever that issue to be resolved is.
Well, if the court is saying that the plaintiff in this case cannot act upon any decisions of this court pending.
That is not what I am saying. That is not what I'm saying, and you know that's not what I'm saying.
Can I ask you a question? Judge, my client wants to ask a question. You can say yes.
Go ahead.
Go ahead.
I mean, we did everything. It seems like we get penalized every time, not in your court so much, but we do everything. We had a global settlement. 3 pieces of property, 1 in Washtenaw, 2 in Wayne County. We all signed, the lawyers all signed what had to be done to get that done. We do everything in the agreement. My family, everything in agreement. They refused to sign a paper, and we're here. And we're getting penalized by getting an eviction. No matter how you rule it, it's against us. Whether we settle something on the 18th or not. We're not supposed to even be here. This is a pending case in Wayne County Court that we all agreed to settle. That guy has the ruling. I don't know what we're
Then,
even here
sir,
for.
you, like your attorney, are not listening to me.
You're
I
saying you're
take
gonna
you
rule
at, if
and
you
give
want to
them their right.
interrupt me, then you go right ahead.
No, I'm sorry. It's just, I've done everything for 7 years. I've worked up in this, and I've got, his client has jerked me around for 7 years. Well, and I haven't been able to live in the house I built. And then I'm gonna get an eviction notice that I know doesn't mean anything to you guys, but to my family, it means everything.
Sir, maybe you and your attorney should listen to what the court is proposing to do. Because both of you have been saying the same thing, that there is this agreement out there that is subject to the jurisdiction of the Wayne County Circuit Court. I'm not going to even begin to get involved in that.
Right. If you're, can I say one thing? I'm sorry, I'll leave.
No,
It's
no,
just-
no.
No, it's,
No.
he doesn't get it.
Judge didn't say. you
He's
couldn't.
always been
Hold it,
good,
hold it.
but
Judge didn't say
I
you
gotta
couldn't.
get out of here before I have a breakdown, man.
Yeah, Judge didn't say you couldn't say it, so why don't you say it?
All I am saying is, there is this agreement. I've not read this agreement. I don't know what this agreement is per se, in terms of how the court is ruling. Not even in a lot of ways have detailed specifics about what needs to be decided. Maybe the issues, sir, that you're raising need to be decided. What I'm saying is, as to this property, if indeed that's going to be decided in Wayne County as part of this agreement, I'm going to issue the order, I would issue the order of eviction, subject to the date that your next hearing is, and giving enough time so that your interest in regard to that settlement can be protected by Mr. Fair. That's all I am saying. I'm not ruling that there's going to be an eviction. I'm not ruling any of that.
Then why rule at all? Why not
Because
wait
it's
till-
my job.
Okay.
Sit down.
Sorry.
Judge, can we rest at this point, and then I have a rebuttal after you speak to brother counsel? You know,
I've worked on this.
He needs to get out.
yeah, well, yeah.
I think you better go out. I'm gonna pass it briefly. You
Whoa.
need to go out and check your
Oh,
client.
no, Judge. he's
No,
fine.
go out and check your client.
I will, Judge, but he's fine.
Avalon Housing versus Yolanda Shepherd.
Very good morning, hearing for plaintiff. Which case? Okay, Your Honor, I was assisting with this woman. I just need to give her some information and then I'll be ready. She's right here. And you, do you want to pass?
Apparently,
Sorry,
court
Your Honor.
calls the case of Faith Shepherd versus Lakrita Thompson.
Carissa Gazari. I'm just gonna, my client is in the hall. Is it okay?
Yes.
Sorry, Your Honor, I was assisting a member of the public navigating the courthouse.
Your name, ma'am?
Laquita Thompson.
Come on up. You're at least ready.
None of us are. Your Honor, client is coming in as well. I had a chance to speak with Ms. Thompson. We have an agreement to place on the record.
All right, go ahead.
Your Honor, this case was filed as a termination of tenancy case. Following the filing of this case, Ms. Thompson provided to Ms. Shepherd's daughter a copy of a lease that had been signed, I believe, by Ms. Shepherd's ex-husband. The copy that I have is not signed by the tenant. In any event, we're willing to allow her to stay until September 30th pursuant to certain terms. So we've agreed to a conditional order of dismissal. The case will be dismissed without prejudice. As of now, there is $1,600 due for rent for April, May, June, and July. Ms. Thompson has agreed to pay $2,000, which includes rent for August, to Ms. Shepherd, either Ms. Shepherd or her
Oh,
daughter.
the 16, oh, it included July because it is July 1st. Never
Yes.
mind. I'm sorry. Go ahead.
So it's going to be a total of $2,000. She is going to pay it in cash and then is going to receive a receipt tomorrow at 4 o'clock at the lease premises.
Got it.
Ms. Thompson is also going to pay the water bill that was due on June 26th in the amount of $233.94 directly to the agency by tomorrow.
Okay.
In addition, she is going to vacate the lease premises by September 30th. She's going to turn in her keys for the lease premises to plaintiff by September 30th. She's going to pay her September rent to plaintiff by mailing a check. She has the address postmarked on September 2nd because of the holiday.
Okay.
She's also going to comply with the lease. In terms of utilities, she is going to pay her utilities timely as she's required to in the lease. She pays utilities for water, gas, and electric. This is the downstairs unit that Ms. Thompson resides in. There will be a tenant at some point moving into the upstairs unit. It may be, mid to end July, it may be August. When that happens, for any utility usage for time following when the tenants have moved in, plaintiff will split those utilities 50-50 with Ms. Thompson until September 30th. So it'll be probably maybe August, yeah, something like that.
Okay.
If she fails to comply with these terms, plaintiff would be able to submit an affidavit of noncompliance to the court with a judgment for possession as well as an order of eviction. Copy will be sent to Ms. Thompson via mail. The 14-day notice and objection period is waived. The 56-day rule is waived. Neither party is waiving any claims or rights under the lease or the Landlord-Tenant Relationships Act. And no one is admitting any fault or liability.
So it's a 4A
It's a what?
on the conditional order dismissal. So 4A or 4B. Is she entitled to a hearing?
No.
No. Okay. All right.
And then if you could explain the 3-day rule.
I will. Ma'am, is all of that your understanding?
Yes,
Is there anything about that that you don't understand or have a question about? All right. And I take it that's not prepared today, the
No.
COD. All right. So when the conditional order dismissal gets to me, ma'am, you would have 3 business days from the date of my signing of that conditional order to dismissal to file to think about it, to file a motion. If you believe that there's some legal right you didn't assert, some confusion or misunderstanding regarding its terms. All right. It doesn't mean that I would set aside that conditional order dismissal, but it does mean that you have that period to think about it and then get before the court if necessary. You understand that? All right. You have any other questions regarding that conditional order dismissal?
Not at this time.
All right. Very good. All right. I will then mark this file conditionally dismissed, and then we'll expect to see an order shortly.
Yes. Thank
All
you.
right. Very good. Thank you, ma'am.
Thank you.
Is our-
Yeah.
Avalon Housing versus Yolanda Shepherd.
Hearing for plaintiff. Jill Bauer here on behalf of Ms. Shepherd. Your Honor, we have an agreement that we'd like to place on the record.
Go ahead, yes.
I do just want to confirm, I don't believe there was a counterclaim in this case. Just confirm that.
I don't see a counterclaim. Oh, hold on.
I don't see one.
I don't see a counterclaim either.
Okay, well, Ms. Shepherd and all other occupants are relinquishing all rights there in the property and the lease premises. They are surrendering possession to plaintiff. We are dismissing the case without prejudice. Neither party is, there's no finding of fault on the part of either party. And Ms. Shepherd wants it known that she's continuing to dispute fault for the case. And I think that's really it.
Okay, how are you gonna do this? In the form of a conditional order dismissal or a
Like a straight.
Straight. stipulation to dismiss with the terms? All right. Is that a correct statement, Ms. Bauer?
Yes, it is, Your Honor.
All right, when is she surrendering the premises? That's today. Oh, well, that's probably why it wasn't said.
Perfect. Yeah, and so I believe, Your Honor, you previously ordered that plaintiff was able to remove the items from her home.
Yes.
So that they could start the demo on these. I believe that there are still items that are now outside that she is gonna be working on, hopefully moving. I don't have privy to those details, but in any event, she has surrendered possession. She's
Right, surrendered the
any
premises.
property that's remaining.
All right.
And
Then I will,
then, Your Honor,
Yes.
can she turn in any keys that she has?
Yeah,
If she
well,
has any.
we can communicate that to her if.
Actually,
let's
no,
say-
it's fine.
Okay,
It's fine. Forget it.
Okay.
It's fine. She's already.
okay.
all right, this case is dismissed per the term stated on the record. Thank you. They ready on it? You said Mr. Friedman left. Oh, okay. Okay.
This is our, I don't know if you want to do your recall. They're both here.
Okay.
Okay.
Let me just do this. Court recalls the case of the Totora versus,
Good morning again, Your Honor. Eric Woodhat on behalf of the plaintiff.
Good morning, Your Honor, and Your Honor, Darwin Fair on behalf of, and Your Honor, if I may, if I could just make one last statement, give Brother Counsel an opportunity to talk. If I can give just a little.
go ahead.
So, all right, Judge. Plaintiff counsel knows the posture. It's based upon what's happened in the past. So they filed a motion to close the case because that is the question, Judge, you always ask, and you wouldn't rule because of the circuit court. So they filed a motion in front of the Wayne County Circuit Court asking that the case be closed. And that was up for hearing a Friday ago. Well, we've been down this road before about a notice of hearing and a precipice. So the precipice wasn't accepted. But at the same time they filed the motion, Judge, they thought or presupposed on that day the judge would rule in their favor. And so at the same time, they filed motions for eviction in this court and also 35th District Court. Well, we both were alerted that the Wayne County Circuit Court was not going to hear the Wayne County Circuit Court case when they had noticed it for hearing. And I was notified by plaintiff counsel that, well, I'll let you know when the precipice is accepted, which means the hearings before this court had to be pushed off until after the Wayne County Circuit Court made a decision. So that is where the breakdown occurred, because then the Wayne County Circuit Court accepted the precipice for the 18th. And so initially the thinking was, well, let's just adjourn this case until after the 18th. I reminded brother counsel, we've been down this road a million times. What happens is whatever date that the Wayne County Circuit Court comes up with, oftentimes either doesn't occur, or if it does occur, the proverbial can gets kicked down the road. Then there was a breakdown, because at that point, brother counsel says, well, let's just go with the hearing, even though this hearing was initially scheduled because it presupposed the Wayne County Circuit Court would make a decision before we got before this court. And so that's why my initial argument for the court was, I don't know why we're here. So Judge, I would like to defer any further argument unless the court has questions. So after brother
I have
counsel.
no questions. Counsel?
I have no objections, Your Honor, to the court entering the order of eviction, but not allowing its perfection until after July 28th.
Court, having heard argument on this case, the plaintiff's motion to lift the stay to the extent that there was one and enter an order of eviction is granted. A writ of or an order of eviction may issue, but here's how I'm going to do it. I'm going to issue it with a firm date of August 1st, 2025 or thereafter. The 56-day rule on the issuance of a order of eviction is waived by the court. That, and so that the record is clear, that should give enough time should the defendants wish to seek other relief before the Wayne County Circuit Court. They may do so, and it is a period after the hearing, and actually it would extend the period out originally contemplated by the court. Regarding the 10 days, it extends it out a little bit more than that. So, all right, thank you.
Thanks, Judge. Always a pleasure.
I need you to prepare.
Yes, Your Honor.
Thank you.
Judge, can we put this on the record that I need to see the order before it gets signed, because brother counsel has a habit of sending orders that I have.
You know what? I'm not going to be between the counsel. Go out there, get a form order. You guys fill it out, approve it before you leave my building.
Sounds like a plan. Yes, Your Honor.
Harbor One versus Rico McGuire. Et al.
Your Honor, Min Kim on behalf of Mr. McGuire, as well as all of you.
Good morning, Your Honor. Deputy Gordon Langley here on behalf of.
All right. Where are we on these matters? Can I dismiss them and get them off my caseload?
We're okay with that. At this point, we, as we indicated last time before you, Judge, everybody that was on the docket has been no longer in a hotel. Everybody's been moved. Everybody's been relocated on their own or moved to alternate housing. So there's no longer an issue with any of those tenants. The property's actively undergoing remediation. We've still got the two buildings, 720, 721 West Clark, 720 Green. They are ready. We are still waiting for city to allow us to have our COCs. Everything on the COC list has been done with the exception of 2 things that the city is requiring Harbor One to do, which is still air quality testing, which we are before Judge Hunky dealing with that. They are also requiring us to place baseboard covers that are fully functioning, but for cosmetic reasons. And there's also an issue of remediation of 4 small areas in the unit that did not pass the smoke test. Those are the only things remaining in these buildings. We would, at this point, there are no health and safety issues from the property management team's perspective, there's no reason these units should not be occupied, but the city is pushing back on that, so we have not gotten COCs yet. They've started the process on the next 3 buildings, 1431 LaForge, 1433 LaForge, and 772 Green. So they're working on those. Property management team says timeline from when we started should be 7 to 8 weeks. Could be less, half the time and half the money without the requirements the city is placing on us, but we work with what we're given. So they're actively working and they're moving down the list to the next buildings. So things are ongoing.
No. All right, so, go, Ms.
If I may,
Kim.
Your Honor,
Yeah, go ahead.
I don't think it's correct that all the tenants have been relocated. I know that, for instance, Mr. McGuire is still looking for other housing. And I'm sure the court is aware of Judge Kunke's partial preliminary injunction, allowing the tenants some options to relocate.
But yeah, and I don't mean to interrupt you. Is that where there was the agreement that the tenant would sign that they would leave and
That is
then?
correct.
Okay.
And I believe we had some emails with Anne about what the court required for the release of escrow, whether they can just submit the move out agreement, the court order move out agreement, or whether they have to file a motion with the court.
And I don't know what, I don't know how Ms. Wadling responded, or did we respond to you on
I
that?
think that you were waiting for a copy of the order. And I.
Well, right, because I think that was right before a hearing. But so there was one case, I'm good. There was one case where what we did is the tenant came up, provided the agreement to us. It was signed off both by, I think, Beal and by the tenant. I read the agreement. The agreement made sense as to what it was saying. And so then I issued an order releasing the escrow pursuant to the agreement and attached it.
Correct.
That is how I thought all of the other ones that were going to happen that did that would take place.
So they do not need a motion. They just need to.
I don't, somehow or another, it has to be. They don't really need, I mean, I hate to go through the whole process of filing motions on it because it is rather straightforward. Just so you know, the young lady that did the other one, she brought it up to the court. Clerk didn't know what to do with it. Got it to us. I read it and then I did the order. Okay, because I understood what was going on. Would I need a formalized motion? No, but would I need some way to recognize that we're receiving it? Because if it's what that person did, I'm going to issue the same order. I mean, it's not like we've got to reinvent the rule.
Tenants and the tenants union about what the court needs with that document, if there's anything additional.
No, but I just have to have something that says I'm submitting this stuff. You see what I mean? I mean, I can't just have loose paper flowing in.
Cover letter, you're saying?
Yeah, that's fine. And just direct it, or if you know the tenants, they could just send, you guys could send us an email asking us to issue an order releasing the escrow. Okay.
And
I just want to make it as simple as we can.
And I just wanted to add to Sister Council's summary that I just got an update from one of the city's attorneys this morning about the process of the administrative reviews, where those are. And apparently Arbor One lost the appeal to the County Board of Review, Construction Review. And also, I guess the other appeal before Judge Conti is still pending. And at the hearing on Friday, there was testimony taken about the air quality testing, and that evidentiary hearing is continuing on July 10th.
I believe, at 9 a.m. And there was some discussion about whether there should be a neutral, not neutral, but I mean a outside third-party inspector involved in all of this. And a conservator was appointed last week. An order is about to issue soon. I think those are the additional updates that I can think of. There is one other concern, Your Honor. A lot of the people that were relocated by Arbor One to the villa side, are you aware?
Go ahead. I'm listening.
They're paying money into escrow as this court requested, and they're being sued for eviction in 14B.
Correct.
Court. And we are representing a couple of them, but it's a big concern.
I had talked to Judge Washington about that, right? Because now these cases are flowing over into various jurisdictions. Certainly, I think that those issues could be resolved in one of two ways. One would be to file with this court an order to either if all the issues are resolved, we would just pay out what's in our escrow to the landlord.
Resolve
Okay.
that way, or
I mean, if the tenant's suing the landlord, the new landlord that's in the 14B jurisdiction, the villas, and all the issues are resolved, it's just an issue of money, then in order to this court saying that can be paid to the villas, I would sign off on something like that. If the issue is that there's going to be some litigation surrounding that, then it would seem to me to submit an order just requesting that this court transfer the escrow to the 14B district court on whatever that case number is.
I'm not quite following, Judge. So these are non-payment eviction cases where the tenants are paying their rent into court escrow here. So
Correct.
you're saying you want the escrow just transferred to 14B?
There's going to be one of two things that are going to happen with the escrow. I guess there's a third option. Either the escrow is going to be subject to the order that Judge Conkey issued regarding the distribution of that because that person has technically given up their other unit. So under that order, it may have to go to the tenant.
So under Judge Conkey's order, if you have asked Arbor One to temporarily relocate you, then
it's 50%.
you're not getting a refund of the monies right now.
I thought as I read it, it was 50%.
They're supposed to be paying, if you're asking for temporary relocation with the intent of coming back to Arbor One, places in the unit that has a COC, or when your unit gets a COC, whatever that winds up being, they should be paying 50% of their rent from wherever they're relocated to.
Right.
If they're being relocated permanently with no intent of coming back to Arbor One and they're being relocated to a place that has a COC, there's no reason why folks should not be paying rent in a unit that has a COC. Judge Conkey's order is very clear that rent is only abated if there's no COC. So if these folks are intending on staying wherever they are, they should be paying full rent to Arbor One. And I will say, Your Honor, we are not handling the township side, so I can't speak to any of the actual.
Of course not, right?
File. But I would presume that if they're not paying the rent to the landlord and they're intending on staying there long term, that's why the eviction is filed.
Go ahead.
I disagree with what, first of all, there's nothing in Judge Conkey's order about paying 50% of.
No, that's the way I read it. The agreement was that if they were voluntarily surrendering the unit without an intention of coming back, they would get all, for our purposes here at 14A, they would get all of their escrow. Right?
If they're giving up and not coming back.
if they're giving up and not coming back. The part I didn't know what to do with, because my understanding was there's this 50% split, is that if they went someplace else, I don't know what to do. There has to be an order or something submitted to the court as to what to do with that escrow. Because my understanding is there was this 50%, which I didn't understand, but it wasn't my order. There was the 50% split to, let me see if it's in this
There
tenant.
was some discussion, Judge, about the 50% because tenants who are placed in hotels had no way to cook their food, et cetera, but I don't think that language made it into the order.
It's not in the optional move-out agreement. I can tell you that much.
Judge Kunke was very clear on the record that her intent was to have residents who are requesting to be temporarily relocated pay 50%. She very clearly asked legal services, Blue, I believe specifically, whether or not she would rather not include anything in the order with regards to temporary relocation and kind of let it be what it may, or consider or order that tenants pay 50% of their rent and make that decision.
It might have just been an oversight, but it's not in the order. But I would have to say that I believe the tenants
I don't know that
are paying, actually, I think they were paying their full rent into the court escrow here.
correct, because the allegation that was raised was that they were being relocated by everyone to the villas in the township. There were issues that were raised as to the fitness of those units. Okay, I don't know anything about that. Those aren't my cases. So the tenant asked me, what should I do? I said, well, we have the escrow open. At that point, there's no case at 14B. I'm aware of that. So I said, just continue to pay your rent here with the thought process that could be the financial pieces could be straightened out rather simply by virtue of an order. If they were sued in 14B and there's an issue, I don't know why you couldn't submit an order to the court just asking us to pay those funds over to escrow in 14B.
So from what I understand, Judge, the tenants that have been relocated to the villas, some may have signed leases to stay there permanently, but the tenants that we're representing, they're there temporarily until their units get their certificate of occupancy. They're in.
Okay, that's fine.
They want to be, or their conditions aren't right, or for instance, there's another tenant who's.
Well, what are you asking me to do though?
I'm not sure what the right thing is, Your Honor. I don't know if 14B should have jurisdiction over those cases in a non-payment case when they have been paying rent. There shouldn't be a non-payment eviction filed at all.
And that may be, I agree with you in the sense that may be your defense to their claim. When they filed the case in 14B, your defense of that is they've been paying their rent all along. Right? It just happens to be here because they got relocated there. So the way to resolve that, it seems to me, is in one of two ways. If those folks are going to be coming back, would be to take the escrow I have here, get an order to send it to 14B to be held as escrow on that case. That would seem to me to be the simplest thing, and then that has to be litigated over at 14B.
And then what would happen to their case here? Would it be stayed?
Why would I stay that?
I mean, they have counterclaims. It's not just about the rent being paid, as you know. Just these people that everyone did not have the right to collect rent since September 17th.
Correct.
So in some
So
aspect, they should just get the escrow release tenants.
I don't have a problem, even if you do the math, with that concept of it coming back to the tenants, if that's what Judge Conkey ruled. I don't have a problem in that. But there's a point at which they're now in the township. Right? They moved. And I don't know that these folks, but you're saying these are not folks that have signed leases. These are people that are just temporarily housed there and are coming back. So let me think about that a second. It would seem to me that those folks that are temporarily housed there and are coming back, that I would release or do whatever with that escrow consistent with whatever Judge Conkey's ruling is.
Judge Conkey's ruling and the move out agreement with regards to the release of escrow are specific to the folks who are entering into this move out agreement. These folks that Sister Counsel is talking about are not subject to move out agreements. There's three options that folks can select. They can select the move out agreement,
Right.
break their lease, and they receive a refund, they're gone. They're finding their own housing, they're leaving, they're doing that. Folks can choose to stay in their units, because quite frankly, a lot of these units have been turned and are perfectly fine, and they are just choosing to stay. Or folks have the option.
And well, let me ask that. So if they stay, they pay rent?
People who are staying are
Whatever.
electing not to pay rent. There are folks who are voluntarily paying rent because they have some sort of other obligations that they recognize, whether it be some sort of assistance or just recognize.
Whatever. Okay.
So, or there are folks who can elect to be temporarily relocated by Arbor One, with the intent of coming back when they can be placed in a COC, a unit with a COC, or their unit gets a COC. So the release of the escrow portion of the move out agreement is only for those folks who are entering into those move out agreements. There's been no discussion about release of escrow or anything of that nature with regards to any of the people who are electing the second two options. So I'm not sure why we're talking about escrow with regards to the folks who are temporarily relocated, because they're not even subject to that issue.
Well, right. And so
I don't disagree with what she's saying, Your Honor, but I think that transferring the escrow to 14B means that Judge Washington will be hearing all of the same issues that this court is hearing, and it doesn't.
welcome to the wonderful way we've set our courts up.
I think that, I mean, I might have to confer with my team, but I think that the 14B cases should probably be dismissed because they are not really not paying their rent.
Well, and I may, for those that have not signed a lease. So if they move over into 14B, sign a lease, and they have escrow here, then this move out agreement is what would apply. Right? Because they permanently relocated, they've said, I'm not coming back. If they moved over and it's a temporary housing until there's a CO, I don't even know how a case is being filed against them.
That's what we're saying, Judge.
But that's not, but hang on a second, that's not my call to make. I mean, if it were before me under the circumstances, I could tell you what I do, but Judge Washington may have a different view of it. And that is, I'd say, well, they're coming over here because their unit is not what it is. So I don't know why you're here asking for non-payment. Because really everybody's just hanging on to these cases because your unit isn't up to date.
And
That, I mean,
there are motions that are going to be heard on July 9th on this issue with Judge Washington.
so you guys have managed to get at least 3 judges involved.
I'd rather just be in one forum, Judge, and I'm renewing our request to stay all of it.
These cases?
Yes.
Well, I think what I'll do is I'm just gonna give another date because so let me just throw something else out there so that everybody knows also why my life becomes difficult. There are tenants who are Arbor One tenants who have relocated to other complexes outside of the villas that are within my jurisdiction, who are now also before this court by their new landlord for not paying rent. It seems that the tenants, that the landlords and the tenants are aware of their circumstance. But I don't know what posture is being taken with regard to the new landlords. And some of these new I think the ones that I just heard, I think they're all Beal properties.
Okay.
But I don't know under what circumstance. There were, I think, 2 individuals this last docket. I don't know under what circumstances they went. So I don't know if they went and it was a temporary thing and then they were going back.
Anybody that was relocated outside of the villas was not, my understanding, the only temporary relocations that have occurred have been to the villas. I don't believe that anybody.
I don't think that's correct. There was a order, Judge, where you said any Beal properties portfolio, properties available in their portfolio that they were transferring them to as well.
Well, I don't know that I mentioned anything about Beal properties. The only thing I mentioned was the villas because I knew they were going across the street to the villas.
But Beal Properties opened up their portfolio to the tenants who.
Yes, I recalled that happening.
And those folks have been signing leases, is my understanding. So those have not been temporary relocations.
I think that.
And see, here's my problem. I hear what you're saying. I don't know that.
Another wrinkle, Your Honor, I think that tenants who signed leases may have felt like they had no other option if they wanted to stay in that new property. If you recall.
I remember.
Beal was making them pay application fees and new security deposits and having them sign leases. And I don't know if the tenants were aware that they could refuse to do so. If you have the names of the
I had 160 cases. I don't remember those 2. You do? Okay, well, then we can get those to you. But I don't know what the status of them is. And now I have this other landlord involved, but I don't. So I'm not sure what to do with those. And I'm not sure how many there are out there. But it would seem to me what counsel's indicated makes sense, that if they're in these other places, they may have signed a lease. And I'll tell you, Ms. Kim, that's what I assumed until you said what you said this morning about the people in the villas getting sued. And they didn't really sign a lease. So.
We have to contact these tenants and, if they're a client with us and see what's going on.
Right. So on these cases, what do you guys want me to do? Because
Judge, honestly, we would request to stay until there's a decision by the circuit court on, whether when they get a certificate, they determine how much rent they owe, if any.
Well, hold it, but this is what makes this so bad. Once the circuit court gets done, and maybe I'm wrong, I'm presuming that they're going to go through for those tenants that dispute as to what rent is owed. There's all that stuff coming back here. Because if it is, oh boy.
Ideally, Judge, would be a overall settlement so that you don't have to, look at every single individual case and there'd be a global decision.
I mean, we see no reason to
From your lips to God's ear, but I don't know.
continue to keep these cases. I think there's obviously a question of money being held in escrow and what's happening with that, but outside of that, I think
these cases run their course, we should dismiss them.
Well, I get that, but you also maintained that from the beginning, but,
I'm concerned.
exactly. But what I'm hearing from Ms. Kim is there would be basically a general objection to that because there may be claims, but
There are some cases of counterclaims. Your Honor.
yes, there are.
The proper thing would be at some point to remove them to circuit court. And we can certainly continue this conversation between us, amongst us, about whether we should just dismiss all of these. But at the moment, we would ask that they be stayed.
Well, and part of my problem is this. I can't dismiss all of them because I don't have a disposition of the escrow.
I guess I was under the impression that Judge Funky had taken jurisdiction of the escrow.
I don't know that.
I mean, I think at this point, the only reference to escrow was in the move-out agreement. There's been no other discussion or disposition of the escrow other than them being able to apply to this court, or if they're subject to a move-out agreement, for court to determine whether or not to release their escrow.
Right.
And we've had one of those requests so far. And
Are you
obviously,
talking Ms. Gamble?
yes.
Yes.
What you entered the order for. And then I believe there's another motion later today, but she's not subject to the move-out agreement as she moved out prior to any order was entered. So that's a totally different situation and request. And so from our position with regards to the escrow, and you'll hear this later, the escrow should be released to be accessible to the landlord for remediation by statute. Your Honor already got it correct by ordering these tenants to put the money in escrow. And so, you've been taking the position that we have to determine what's going to happen, and that will happen at a, later date. We're maintaining that this property is actively undergoing remediation. Statute is very clear that says if there's no CFC, tenant should be paying into escrow, and that money should be used for the purpose of remediation.
It can be, right.
Yeah, and so that's, if we're getting to dismissing these cases and dealing with the escrow, that's, what the escrow should be used for in our position, so.
But I don't know, and maybe or maybe not agree with you on that. I don't know what tenants are still there.
And that would impact whether or not the escrow was released for remediation purposes or.
Right, so frankly, I don't have enough information because I don't have the whole case. So I don't have, I may have a tenant that has escrow in here. I'm unclear what to do with it because I don't know, should this tenant be subject to the move out agreement? Have they voluntarily done whatever? Are they just temporarily there, either by virtue of Arbor One putting them there, or did they kind of voluntarily move themselves temporarily and they're intending on coming? I don't know. And I think those things, the escrow, what to do with the escrow becomes different as to what to do with the escrow just on those scenarios, and I'm sure there can be more. But Mr. Friedman, if you're saying Judge Kunke took jurisdiction of the escrow, I'll send it all up to her. I'll be good.
I'm not sure she did, I'm not sure she did. Frankly, to be blunt, some of it's kind of confusing because she's saying it can be used for this and in a sense, she took jurisdiction over the escrow because she said what can be used. She said that it can be used for certain purposes. So
You mean in terms of remediation of the
So
unit?
I believe Mr. Freeman's referring to the terms of the move-out agreement.
Got it. Yeah, so I don't have any problem, once I saw the move-out agreement, like I said on the Ms. Gamble, I don't have any problem dealing with it, how I dealt with it. Of just issuing the order once I had the signed agreement and we attached that to it. Didn't have a problem with that. That's the only case I've got.
Yes, Judge. There are people I'm sure moved out before the order was issued and
Before which order?
Judge Kunke's order. And unfortunately, those tenants, they can't access the benefit of that agreement. Maybe we could can I propose if we?
Oh,
status-
because they,
Moved out prior to, the move-out agreement is specifically for folks who are currently at Arbor One, who wish to break their lease and leave to find their own alternative housing. And so if somebody's vacated months and months before, they can't now come back and say, oh, I now want to enter into a move-out. They've already moved. It's a move-out agreement for folks who have not moved and are still at Arbor One. So there are folks who have already been relocated or who have already decided to leave on their own. And so that money and if there's being held in escrow, it's our position that should very clearly be used for remediation purposes. With regards to the folks who are submitting move-out agreements currently, who are planning to leave Arbor One and who are currently residing there, I can understand, Your Honor, that could be a different situation as to looking at what's to be done with the escrow. At the end of the day, our position is the statute is clear. Any money that is being put into escrow with regards to somebody who is living at the unit when there's no CFC, that money should be directed to remediation. And so, quite frankly, it's kind of all encompassing with regards to the statute. The statute trumps the ordinance, which says that they are not required to pay rent with no CFC.
Your Honor, I disagree with the interpretation of the preemption issue, which I think was part of Arbor One's motion recently that Judge Kunke heard on Friday, and it was denied. The preemption issue, because the city code says something else, and there's a
oh, I know.
that says that the municipalities can have a higher standard or more protections for the tenant. So we're not asking the court to rule on that today.
And I'm not going to.
And council keeps remediation, but I think that most of their funds are going through litigation, honestly. And they have said many times that money is not an issue with making all of the repairs in objection to having a conservator. So I think the little bit of escrow that this court is holding right now is just tiny little pennies that will not really make that much of a difference in their remediation efforts. That's just my opinion, Judge. But I would ask that you give us an opportunity. We can come back to talk about potentially dismissing these cases, but we would have to deal with the cases.
You're coming back.
With counterclaims. Unless
I got you. And I think what I'm going to do is I'm going to give you a date into the future. Let all of this sort out. I am always available if you guys have resolved certain things to it. You know, if you resolve a particular case, I don't have a problem issuing an order doing X, Y, and Z. I mean, I'm not going to have an issue with that. One other issue do I dare say, so I'm going to need something about a month and a half out, please. There is this large monies that I had, or large, relatively speaking, in this case, like 50, 60,000. 65.
Yeah.
So did we?
I have reached out to the city's attorney to inquire on several occasions about them submitting something to the court pertaining to what that money will be used for. We would like it to be used for inspections fees pertaining to these two buildings and applying those. I've got nothing back. At this point.
Okay, well, something has, all right, no, I hear you. And something has to be done because those funds were paid in good faith. Because there was this rather bizarre notion that there were bills that weren't paid, so they couldn't move forward. And so I said, well, how many bills do they have to pay? And what are the bills? And they couldn't give me what the bills were. And then an odd thing happened that really does bring it to light in my mind. The amount that was owing on those past bills, typically I would have thought that Arbor One would have given me a lower figure that was owed, as opposed to what the city was saying. But the city gave a lower number. Arbor One gave me the 65 or whatever it is. They paid it in good faith. Since it was taken in under those circumstances, there needs to be some, they said they couldn't take it and then apply it to what bills, which was bizarre to me. But I thought I was going to get a list.
And we've asked for that. I've got emails to the city attorney asking them very specifically to ask their client to prepare a list. It's become incredibly problematic as of this week as well, because we've got this money being held that we would like to be used for fines, and the city has now filed 40-some liens against us for fines. And so that's happened as of this past week. And so this is, the type of things that we were hoping to avoid. And so now we have to deal with that because the city won't get back to us about, and this is, and like I said, we're moving on to the next 3 buildings. And so we're trying to get this going, but we can't even get the money applied for the 2 that we're dealing with now. And so that's been an issue. So I don't know what more Arbor One can do with regards to reaching out to them, because that has to come from the city. We've made their request as to what we would like it to be applied to. But yeah, I mean, I can reach out again today after the hearing and indicate that.
Do you have, that the number you gave council, I'll tell you what I'm going to do. We'll just do it this way. When you paid the 65, whatever in, you had certain bills.
Well, they actually had returned checks, if you remember.
Correct.
That were good.
So yes,
we're talking about NSF checks. We're talking about checks that were not stale.
$50,000 checks. So yes, we had numbers. We were able to pull from the BSNA website or pull from our own records and see what was due. So we could, if the city's not going to do it, in order to get the money, we can pull the numbers together for these 2 buildings and see.
Here's what I'm going to do. I think yeah, go ahead.
I just feel like releasing the money to Arbor One.
No, it's not. No, that's not. It's going to the city.
But Your Honor, that is going to the city for payment of Arbor One fines, right? Is that what we're talking about?
They're inspection fees, which is why I took it in the first place. I don't know if you were at that hearing, but it was bizarre to me what the city was saying to me. The city was saying, we will not do any more inspections because they haven't paid these fines and whatever in the past. I said, okay, well, how much do they owe? And they gave some figure. Hold on. No, you need to hear this because this was bizarre to me. And then I said, well, if they each had a number, and I said, well, just pay it to the city and they can sort it out and apply it to whatever bills are owed. They then said, oh, we can't take money that way because they don't want us to. They don't know who they are and what that meant. So then it ended up that I took the higher number.
It was the number plus 20 or 25%. It was 20, I think it's 25% over the number.
Whatever number it was. Anyway, that I took that in and I said, okay, with the thought, get me the bills that need to be paid, get an order, we'll release the checks, those will be paid, to not hamper further inspections on the premises. That was the intent.
I guess, Your Honor, what I'm trying to say is that these funds belong to tenants.
No, no, these don't belong to the tenants.
Until it's litigated or.
No,
there's decision
these
made.
funds don't belong to the tenants.
She doesn't have a dog in this hunt.
Yeah, I know. The funds that we're talking about, Ms. Kim, are not tenant paid or landlord paid escrow
Oh, okay.
for that.
What-
It was taken into escrow so we could, just understand this. So that the bills and fines that the city was complaining about could be paid so that further inspections could happen. Because the city would do nothing unless this was paid.
But the funds that we're talking about, are they not escrow funds from the tenants?
No,
Oh. Okay.
no.
What are the source of these funds that we're talking about?
These were the landlord's monies that they were gonna pay to the city of Ipsy that the city of Ipsy wouldn't take.
Privately held money from the landlord.
Got you. So we're not talking about tenant escrow at
No,
all?
not at all.
Okay, we've moved along. I'm sorry, y'all.
We did that about an hour ago. Nice of you to catch up. All right.
Glad we're on the same page.
No, I bring it up because I need I'd like to dispose of that.
We can get, yeah, that would be.
So here's what I'm gonna do. I'm gonna order that the parties that I have before me are to provide me a list of how those escrow funds are to be dispersed and to what bills they should apply at the city of Ipsy. You're to do that within 10 days.
This is not tenant escrow.
This is not tenant escrow. This is the funds that we're holding for the payment of that,
And how much is being held, Judge?
about 65,000,
The dollar amount on that big check was 62,000.
62,000. All right.
And can I ask if the court knows how much tenant escrow is being held here?
We absolutely do. Give it to me, please. There's an additional 10 though.
Mm-hmm. Yeah.
So it's going to be 21,590, right? Or there.
590, Your Honor?
So the plaintiff also
Had
right.
Right.
Correct. Mhm, yeah.
Okay,
And then
so
this is
we're at about
specifically-
20, right?
And are tenants continuing to pay for escrow right now?
I have no idea. I don't know when the last payment we got. We updated occasionally, but. Okay. What I have is I have about 84,000 that I'd like to dispose of in some fashion. 62 of that being what was paid to the bill. So I'm ordering, let me just get back to that. I'm ordering that. That's to be submitted within 10 days. And I'd suggest, let's do it this way. Submit it under the 7-day rule to me.
Both?
No, for the 62.
But you want both of us to submit a 7-day?
No, no. Really, Miss Kim, you're not in. The tenants aren't, the tenants really weren't involved in this. This 62 was paid by we were looking to get repairs moving and inspections moving. The city said, and I'll just say it again, the city said they could not do inspections because they haven't paid this, whatever. So I said, well, how much is owed? We came to a figure. I said, well, go ahead with the inspections. Now the court has some money. Right? I don't know that that's occurred, but anyway, I had the money. I then asked the city the last time they were here to basically give me a breakdown of what bills it should be applied to because they said they couldn't take the lump sum and do it themselves. Okay, I've got nothing. So now I'm ordering parties to give me something, file it under the 7-day rule, and then those particular funds I'm going to disperse for that purpose. That's what I'm going to do. Because
You said under the 7-day rule, okay.
Yep.
So not 10 days?
well, you have 10 days to do it, but submit it under 7. However you want to do that, because there's different reading of that rule. I'd like it sooner. I'd like it sooner than later.
Beautiful.
I will just
And-
note one other thing. Just
No, go ahead.
knowledge. I believe that Ms. Kim mentioned that she received information that our appeals had been denied by the Board of Appeals, which we did appeal the red tags to the Washtenaw County Board of Appeals. They did deny those, but we've appealed them to the State Commission, and those are pending.
Got it.
So that is still all in place. No decision has been made. I believe the meeting for that are July and October, respectively. So we will be dealing with those accordingly. And as Ms. Kim also mentioned, Judge Kunke on her own mentioned to the parties on Friday about sua sponte, ordering a independent third-party inspector. We've been making our claims to her that, there's a lot of stuff going on here with, disparate treatment. So seems like she's hearing that. And so we're briefing to her by Thursday her authority to do so, and why that would, substantially benefit the process of getting these buildings online. So that's being briefed to Judge Kunke by Thursday. And so, yes, I think that was all of the major updates here.
All right, real good. And what I'm gonna do, other than the 62,000, I'm not gonna do anything at this point with any of the escrow, except as is consistent with Judge Kunke's order, if there's a move out. Otherwise, I'm not doing anything with it unless the parties agree that it be sent someplace else. I'll get that other order and then we'll adjourn this to all of these.
Tuesday, August 12th at 9 a.m.
Tuesday, August 12th, 9 a.m. And then we'll see where we are. Okay,
Thank you, Your Honor.
thank you.
Enjoy your summer.
Huh?
Enjoy
Check
your
that
summer.
date really quickly, Your Honor, if you don't mind.
It's too late. I'm not gonna enjoy my summer.
That Tuesday, August
12th. Yes.
Okay, that works, Your Honor.
It works. All right, fantastic. All right, thank you, folks.
So this is fine.
Did they have an order?
I'm sorry?
Those two, did they have an order?
Yes,
Where is it?
there's a motion on it.
What?
If I were also the motion, I didn't know if you were addressing it. now.
Oh. There is a motion, another motion.
Yeah.
Let me get this order here.
Yes.
Yes.
That's the order.
Do you decide in her, Your Honor, that, may have something to say?
No. We're not going down that road, Your Honor, please. If she won't file an appearance and she wants to, it's not appropriate for her to interject herself into this without being on the record, period. I'm not. Once again, she doesn't have a dog in the hunt.
I've signed this. We'll get copies to you.
It's a dog. Thank you.
All right.
We don't fight dogs anymore.
Oh, right. Gotta have PETA down here in a minute.
I know when the motion was submitted, there was submission statement that she's not representing. That's to my knowledge on. It's submitted for her, but she's not represented by counsel, so we're prepared to move forward with.
Is she here?
She wasn't. She's possibly dialing.
Hello.
Hello, what's your name?
Denise Llewellyn.
Okay, Miss Llewellyn, I guess I'm gonna do it this way. Are you intending on being represented by counsel?
Yes.
Pardon?
Yes. Legal aid. time was legal aid.
Yeah, okay. Are you guys gonna represent Ms. Llewellyn and file an appearance and answer?
File an appearance and do not intend to represent Your Honor. But we are very familiar with the situation, and if the court has questions, I'd be happy to.
Yeah, but Mr. Friedman makes a good point. I don't know who's, from the court's perspective, I don't know who's answering back. I mean, it's sort of, I'm getting these sort of phantom arguments and I can't, it can't operate that way. More importantly, Ms. Llewellyn, I mean, in fairness to her, I think she believes she's being represented.
I've
But
been dealing
she-
with this since
Pardon?
since court started. I said I've been dealing with legal since we've been started almost a year ago. With
Okay, you
Arbor
broke
One,
up there.
know.
Say that again, Ms. Llewellyn.
I said I've been talking to legal aid since Arbor One been going to court. So I thought I was represented because I've been talking to them. I've been emailing them. They've been emailing me back. I don't understand what's going on now.
I believe that Ms. Llewellyn was.
May I approach?
Because I've been trying to break my lease.
Okay, hold on, Ms. Llewellyn. Come on.
Okay. This is a lot. I've been dealing with this shit since the beginning. Jeez. I sure did just cuss in the court. I'm sorry.
To proceed on your info.
Okay.
Okay. During that
Okay.
week or so, I need you to talk to legal services. And my purpose in adjourning it is so that there's a clarification on whether or not they are representing you or whether or not you are going to proceed on your own.
Okay.
All right? Thank you.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
This shit is retarded.
That's it for this morning.
It is.
Are you Darren Furlong? And Mr. Rojas, will your client waive the formal reading of the indictment in each case? Mr. Furlong, in cause number 250515, you're charged with the third-degree felony offense of obstruction or retaliation from January 1st of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? And then in cause number 250517, you're charged with a second-degree felony offense of assault on a peace officer from January 15th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Judge, just so the court is aware, if I may,
Mhm.
although very disrespectful, his behavior, that assault did not injure the officer. He just kicked him in the leg. I'm
Okay.
not minimizing. it.
Right.
He wasn't injured.
Thank you very much, Ms. Morfino. Mr. Furlong, in each of your cases, I have here on the computer some documents that you have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Mr. Furlong is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. And at this time, in cause number 250515, find you guilty of the third-degree felony offense of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 250517, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run concurrently, which means together at the same time. And I'm going to sign dismissals as part of that plea agreement in cause numbers 250518 and 250516. I think you might have to print 15 for me. I already sent it back, please. I'm going to hand you in each of your cases trial court certifications that shows that you have waived your right to appeal because I've followed those plea agreements. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir. And we've got one more printing for him. And then if you'll send, I'll sign those dismissals as soon as they come through. Mr. Nix, you have Ebony Broussard?
Yes, sir.
Okay. All right, as soon as she gets done with all that paperwork, I'll, actually, I'm gonna start. And I'm trying to print those MTRPs and it's saying the Unity print spooler has stopped working. I'm gonna try again just for fun. Okay, that's the first one. All right, I just printed all three of those motions. Get it right for me, that'd be great. I just need the motion. I don't need all this extra. All right, Ebony Broussard, Mr. Nix. Good morning. How are you? Good morning, ma'am. Are you Ebony K. Broussard? And Mr. Nix, will your client waive the formal reading of the motion in each case?
She will, Your Honor.
Ms. Broussard, in cause number 19-32806, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 21st, 2020 for the second-degree felony offense of assault on a peace officer, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 19-32518, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 21st of 2020 for the offense of escape while arrested or confined, a third-degree felony, and that was a 10-year deferred probation as well. Is that correct?
Yes, ma'am.
And then finally, in cause number 21-36615, I have a motion to revoke your unadjudicated probation. This shows you were placed on probation July 12th of 2021 for the state jail felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that also correct?
Yes, ma'am.
Each of these motions allege that you violated your probation. Count 1 in each case alleges that you failed to report as directed to the probation department March 18th of 2025. And is that true or not true?
Yes, ma'am.
True or not true? Thank you. Count 2 in each case alleges that you failed to immediately report to the probation officer your 2024 tax return documents. And is that true or not true? And then finally, count 3 in each case alleges that you were behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
In each of your cases, I have here on the computer some documents that have your signature on them with Mr. Nix that shows that the district attorney's well, let's see. All right, so before you went over these, did you, good grief, before you signed these, did you go over them with Mr. Nix?
Yes, ma'am. I did.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made in all of your cases that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is to continue you on probation, to order as a condition of that probation that you enter and successfully complete the cognitive track of the ISF program. And
Computer was being a little temperamental. what that is intended to say is that she's in good faith going to pay the money that she has up front via her family, the $2,040 as a good faith effort towards her fees.
Okay, and so you have that $2,040 now, and somebody's gonna get that paid?
I do, Your Honor. They brought it to me in cash, and I'm going to write a firm check for the actual amount as opposed to handing them cash.
Sure, okay. And that's your understanding of your agreements in all of your cases, is that correct?
Yes, ma'am.
And, let's see, it looks like this one did the same thing. When you're done, Mr. Nick's signature's not coming through. What a fun day with technology. Oh. Did I do that? I could have done that. That could be me. All right, so state tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Broussard's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 in each of your cases freely and voluntarily. Find those counts true. Find sufficient evidence in each of your cases to find you guilty and revoke your probations, but I'm not going to do that. It sounds like probation's here. Like, everybody wants to work with you so that you can be successful on these probations. So you need to really go to ISF, learn the tools that'll help you make better decisions so that when you get out, you still have no felony conviction on your record.
Judge, based on Ms. Johnson's request and some interactions with Ms. Broussard, as well as those jail incidents, you might want to fill the court in a little bit more. She needs a little bit of admonishment on her attitude.
Okay. Is there some jail, do I have some jail reports on this one?
Have them here, that would be helpful.
Well, I think I probably went through them
Here's the
yesterday.
latest one.
That's okay. I've got them right here. Thank you. So it doesn't look like you like following the rules is what this appears to me to be. And so here's the thing. If you're not on a felony probation ×3, you can do whatever you want. You can run around your house naked. You don't have to wear your jumpsuit a certain way. You don't have to follow anybody else's instructions. But when you're on felony probation, you have to follow rules that you may or may not like. You have to be respectful to people who are in charge of you, who are just doing their job. Your probation officer and out at the jail. And how old are you? 40 years old, and you're doing this nonsense in our jail? This is the stuff, this is the stuff that I keep reading about the young ones in our jail. Not that being in jail is a role model, but you're old enough to be there and say, look, I'm doing better. Do better there. Encourage others to do better. Encourage the younger ones to do better. Don't encourage them to do worse. There more that I need to know about?
No, ma'am. That's pretty much how it's been is, with the attitude, it's following instruction. And when we give her instruction, she usually gives us some pushback. So yes, that's pretty much
Okay.
the whole.
So this is your second opportunity.
Yes, ma'am.
You're not going to get a third opportunity.
Yes, ma'am.
In one of these cases, just one of these today, I could send you to prison right now for 20 years.
Yes, ma'am.
Today, I could do it right now. I don't have to take agreements on these motions. I can do whatever I want within the realms of the law and the realms of the terms on each case.
Yes, ma'am.
2 to 20, 2 to 10, up to 2 years. I could do all that right now today. If you continue to be disrespectful to your probation officer or out at the jail, then you're going to be back in here and it's not going to be nice. Do you understand? I don't care if you have young children. I don't want to hear any excuses. Oh, be nice next time because I have young kids, or I need to be there for somebody. Change it, change your behavior so that you can take advantage of this opportunity.
Yes, ma'am.
Okay.
I'm sorry, Ms. McCray.
Thank you. All right, then, I'm going to, again, continue you on probation, order that ISF in each of the cases, and then when you're out, as soon as you get out of ISF, go straight to probation and continue that probation, hopefully successfully, so that you can finish it, get off of it, and not have any convictions.
Yes, ma'am. Thank you.
Your Honor, if I
Yes.
can add one thing,
Uh-huh.
and even though it's not part of the agreement, it's everybody's understanding, when she gets out, she's gonna bring her tax return, which is one of the violations.
That's required. So, okay, so it's not that hard to do. So when you do it, it's just another one of those things. Follow the rules.
Yes, ma'am. I sent it to.
Hang
her.
on, listen, just, you need to do everything that you're supposed to also on probation's time frame
Yes,
and not your own.
Yes,
All right, so it's very important when they ask for something, get it done immediately. When they ask for it, not sometime futures, don't make them ask for things over and over again, all that kind of stuff, okay?
Yes, ma'am.
I'm going to hand you in just a second, hopefully, the trial court certifications in each of these cases that shows these were agreements that I followed, and so you've waived your right to appeal. I don't hear anything happening though. And at least, let's see, hold on that first one, the second one's fine. The first one needs Mr. Nick's signature. And let me check the third one. Did two print or just one? So that's 06. So I'm about to do 15. And none of y'all's signatures came up on this right to appeal, but I went through it with her, so I'm going to sign it and do it. Is this all because of the update? Or what is happening?
I don't know. This is the type of problem we had last week, or yesterday and last week. Things just disappearing.
Okay, here's those documents, Mr. Nix.
Judge.
All right, good luck to you, ma'am. And thank you for being here. All right, here's those three. You don't have to be scanned. And here's this. Oh, I just did it. I just did my. I just I just caught myself with my frustrated sound. We're halfway through and it's the first time I did it, so let's see what is happening with this. Why this looks like this. Yeah, it's probably me. All right, we did that. So Ms. Holmes, Ms. Brazo, Mr. Lewis, all three back there. Good morning. Are you Lawrence Marks? And Ms. Prazo, will your client waive the formal reading of the indictment?
You will, Your Honor.
And are we going on count one only?
It doesn't really affect anything, but yes, Your Honor.
Okay, I'm getting there. Mr. Marks, in cause number 24-1763, the state's elected to proceed on count one only. It alleges you committed the second-degree felony offense of aggravated assault with a deadly weapon, and that is from July 31st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up, please. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazo? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Marks is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon, sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Perazo. Good luck to you, sir. You can go back with the bailiff. And do you have Johnson's paperwork? Avion Johnson?
It was on the tab, I think, so I signed it. He's already been ready. You hold for just a second.
I remember.
Okay, that sounds good. Like 10 years ago with a trial in this court.
I remember. I mean, I don't
He's not even
necessarily,
on parole.
I don't even remember the. I remember. Okay, this is, are you Avion Johnson? Come on over to the center, Mr. Johnson. And Ms. Perazo, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Johnson, in cause number 24-2044, you're charged with a first-degree felony offense of arson, intending damage to a habitation or a place of worship from August 1st of 2024. And how do you plead to that charge? And are you pleading no contest freely and voluntarily? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazo? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. Any fine?
No fine, Judge.
Is there restitution?
We're gonna, I don't believe there is any, it doesn't appear that there is that has not been already satisfied, but just to be on the safe side, we'll take a look at that.
Okay.
And PSI if we may.
All right, is that at your understanding of your agreement? Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Johnson is not competent? All right, sir, I'm going to find that you entered your plea of no contest freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. And that'll give me more information about you, your case, and then we will come back at a later date for sentencing. All right, you can go back with the bailiff.
Thank you, Your Honor.
Yes, ma'am, thank you.
Thank you.
See, Ms. Holmes, you have Christina George. What are we doing on that?
Yeah, that's the one with the safe P.
Okay,
So, I guess could we reset a couple of weeks, I guess, to see if Horn County can put the hold on her and
yes,
come get her?
that would be very helpful. Yeah,
Yes,
let's
ma'am.
reset Ms. George 2 or 3 weeks.
Okay.
And then Ray LeBlanc,
Yeah, we're ready on that.
is there paperwork?
Yes.
Okay, I don't have that yet, so hang on just a second.
There he is.
Okay.
Take your fingerprint. You have Jennifer's number if you like.
And what are we doing on Kendrick Williams?
I'm still working.
Okay. Yes, ma'am. Okay. Good morning. Are you Ray LeBlanc?
Yes, ma'am.
Can you hear me okay like that?
I can hear you.
Okay. And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. LeBlanc, in cause number 250460, you're charged with the state jail felony offense of burglary of a building from February 5th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes,
Do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
Okay.
You're a U.S. citizen.
Oh, yeah.
Okay. I have to ask everyone. State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. LeBlanc is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, so you've waived your right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Okay.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices. I'm required to read it to everybody.
I'm never on the firearm in my life.
I've got to say all these words, sorry. So you should read that to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Good luck to you, sir. Thank you, Ms. Holmes.
Yes, ma'am, thank you. Okay, so, yes, so they have you on the docket today, in this court, your attorney's name is Jennifer DeLay. Okay, so I'm gonna contact her to make sure she comes back to see you. They're gonna tell them to bring you over to county court right now.
See, Mr. Lewis, you have Derek Ardwan.
I'm telling them to bring you over to county court right now.
Thank you.
Derek Ardwan. Morning. You've been back there working. You got them piled up today. Looks like a gold star in the making. I don't know yet. We'll see. What?
Why does he get a gold star?
Because he's got 3 pages of docket that he's taking care of.
2 of those are mine.
Okay, so y'all can share the gold star. Good morning, sir. Are you Derek Ardwan? And will your client waive the formal reading of the indictment? Mr. Ardwan, in cause number 250350, you're charged with the second-degree felony offense of sexual assault, and that's from July 15th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 6 years in prison, which means if I accept this agreement, you're leaving your punishment up to me. And I cannot give you more than 6 years. I could give you 6 years, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing. You have an absolute right to have a jury come in and determine 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, you can leave your punishment up to them. If we go forward this way, you're waiving that right. And is that what you want to do? Also, do you understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, as a result of this plea, it looks like you have gone over with your attorney that you will be required to register as a sex offender, and it looks like you've already signed that document and those admonishments. Is that your understanding as well? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Ardwan is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis, and he will present it to me on your behalf when we come back. All right? You can go back with the bailiff. See, Colton Armstrong.
That one, Judge, I think Bruce Smith filed a motion to set up this morning.
Oh, just this morning? Great. Looks like Colton Armstrong's going to be reset. If you'll make a notation that he's supposedly hired Mr. Bruce Smith this morning, and so we can be kind of watching for a letter. James Burrell, Mr. Lewis.
Yes,
Good morning, sir. Are you James Burrell?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the motion?
He does, Judge.
Mr. Burrell, in cause number 22-39838, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation May 23rd of 2023 for the third-degree felony offense of theft, and that was a 10-year term in prison that was suspended for 10 years. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department May 14th, May 23rd, June 11th of 2024. And is that true or not true? Count 2 alleges that you failed to immediately report to your probation officer your change of address and phone number. Is that true or not true? I'm sorry? Okay.
I think the state would be willing to waive counts 3 through 5. However, we could be asking for some sort of plea on 6 and 7.
All right, so the state's going to abandon 3 through 5. Count 6 alleges that you were arrested for the offense of possession of a weapon by felon June 19th of 2024 in Orange County, Texas. And is that true or not true? And then count 7 alleges that you were arrested for possession of a controlled substance June 19th of 2024 in Orange County. Is that true or not true? Did you enter your pleas of true to, I'm sorry?
No.
Oh, I thought I was going to say. Did you enter your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Burrell is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody, but the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I went over that with you back when you first got probation, right? So just make sure you read that and know that because of this judgment, you cannot possess a firearm.
Yes, ma'am.
All right, good luck to you, sir.
I thank you. Thank you, Ms. Lee.
Yes, sir. We had to bench warn him, so he got some times, I guess, from Orange to 1, 2, 6. Mr. Lewis, you have Eddie Garcia Aragon. That's a sentencing.
Judge, I know for the PSI that he has the ICE hold and a deportation detainer. I don't know if the plea, if we need to revisit maybe doing a 1244.
Yeah, I'm not inclined to give a probation to someone that obviously is here illegally. So, what I can do is reject, once he comes out, I'll reject it. Y'all can get some new paperwork, renegotiate what you want to.
Based on that detainer, would the court be willing to accept it? 1244?
For this offense and the, like, yes, like history here, that's fine. Good morning, ma'am. I'm sorry you've been waiting so long. I didn't even realize you were here for that, and I saw you sitting out there. You need to wave me down and say, take care of my stuff. Would you please raise your hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God?
Yes, ma'am.
Thank you. And sir, are you Eddie Garcia Aragon?
Yes.
And Mr. Aragon was previously in court, entered a plea of guilty to burglary of a building, I've received the pre-sentence report. And part of that report has given me the information that Mr. Garcia Aragon is not here in the United States legally, and that there is a current hold for immigration on him. And because of that, I'm not going to accept the plea agreement for probation. So at this time, I'm going to reject that plea agreement. I'm going to hold the case for a few minutes. You guys can go back and visit and see if there's something you want to work out different this morning. We can get it taken care of while Ms. Burge is here if possible. Okay. And then Desron Roberts, Mr. Lewis. You good over there? I feel like it should be later than 10:30.
I know, I looked up, like, it's.
Like, I feel like we've been here for a long time. Good morning, sir. Are you Desron Roberts?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Roberts, in cause number 241821, you're charged with the state jail felony offense of possession of marijuana from December 4th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone that question. State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Roberts is not competent?
No.
And is there any history?
There's misdemeanor history, Your Honor. There's no felonies, although there is one pending testing that looks like it'll end up as a second-degree possession of methamphetamine. Testing's not yet been completed, so no case has been brought to our office.
Okay.
I'm just looking at his record, and I don't know any other circumstances of the case other than it shows a likely second-degree possession. I would assume that'll end up as a probation concur with this, but I don't have anything else.
All right. So I think what I'll do, just to make sure we have that all lined out and possibly give them time to get that done, is I'll get a PSI, but I'll do something on the bond.
It was an April arrest, and on the lab portal, it just says testing pending.
Okay.
Doesn't have anything done yet.
All right. So, I'm going to, where did I stop when I started asking about that? Too many words today. Did I already tender number 1? Did we already do that? Okay. So what I'm going to do, Mr. Roberts, is based on your plea agreement, I'm going to reduce your bond in your case to $1,000. I'm going to make that a personal bond, which means you don't have to pay any money. You're just going to get out of jail, but there's some very important things about that. All right. So the first thing is that as soon as you're released from, it's a big smile going on. That's good. Hopefully you'll stay smiling. You'll do everything you're supposed to. And how old are you? 26.
27 next week.
Okay. So you're going to change your ways, right?
Yes, ma'am. I have to.
All right. So yes, you need to then, for sure, for yourself and for them. So the first thing you do when you're released from custody is go to the probation department, because they're going to do a pre-sentence report. You've got to do an interview with them. And if you don't go do that, then when you come back, you run the risk of me raising your bond, going back to jail, and me not accepting this agreement. You understand? Also, if you are arrested for anything between now and when you come back, you obviously run the risk of me not accepting this agreement. The last thing is I am going to require as a condition of your bond that you wear a drug patch. All right, you have 24 hours from the time you're released to get that drug patch on. And then you need to get proof of that to Mr. Lewis. Since I don't have a bondsman, I'm going to have Mr. Lewis get that information and then get it to us so that we know where he has it and we can contact them and they can send us the results. So drug patch is going to be on your arm. You go every 2 weeks and you get it changed. If it tests positive and it shows me you're using drugs, obviously we're in a whole different situation. Okay?
Judge, Mr. Roberts turned down an option that would probably get him out in the next few weeks. And I think the idea was to prevent himself from becoming a felon.
Good.
And so with that in mind, I think I'm hopeful that he is committed to straighten his life out.
That's good to know because sometimes people will just take a short amount of time to get things over with.
I wanted the probation in order to keep myself clean.
Yeah, keep yourself clean and keep a felony conviction off your record. Now, obviously, there's another case that's out there, it looks like from some time ago. Once that's filed, there probably will be a warrant. You'll have to go turn yourself in. We'll get it sounds like another probation that'll run with this one, but you're going to have to go through that process as long as you're doing everything right while you're on this probation until that comes, right? Okay, we'll see you back at sentencing. Yeah, and Mr. Lewis, if you want to go maybe work on Mr. Garcia while Ms. Burge is still here, and I'll hold your other ones. And who'd you want to come? Yes.
So, I think I have a conflict. I represent the co-defendant.
Oh.
But on the CPS side, it's because of this case, the cases though, the injury to a child
Oh, yeah, I would think that would still
And
probably.
Barbara represents the co-defendant here, but I think there would be a conflict with me using the co-defendant.
Sure.
if Ms. Holmes on.
Absolutely. Okay, so let's do this. I'm gonna, based on that information, I'm going to release you, Ms. Holmes, as the lawyer for Mr. Williams. Let's get one of ours, either Mr. Parker or Mr. Rojas, appointed today, and then they can, if you'll get whatever you have to them, and that way we can get it moving along that way.
Okay, and it looks old, Judge, by age, it is, he was at large quite.
Okay.
Almost a year before the,
Got it.
sent the marshals for him.
All right, thank you very much. Thank you, Ms. Holmes.
Yes, ma'am.
And so Mr. Williams can go back. So now it's just Mr. Lewis. Okay. Okay. Mr. Lewis. Now that I'm looking at it, I probably could have just changed the plea agreement, but we'll go through the whole thing. All right, this is cause number 240282, and again, you are Eddie Garcia Aragon.
Yes.
And will he waive the formal reading of the indictment?
He does, Judge.
Mr. Garcia Aragon, you're charged with a state jail felony of burglary of a building from January 21st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have on the computer some documents that have your signature on them that the state's marked as Exhibit 1. Did you go over these with Mr. Lewis before you signed them?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you'll be waiving or giving up any right to appeal?
Yes.
Also, do you understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, I understand.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Garcia Aragon is not competent?
No objection.
I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the consequences of your plea. Find sufficient evidence to find you guilty. And at this time, find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. Shows that I followed the agreement. So you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. That admonishment is in Spanish. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Make sure you read that to understand the law. And if you have any questions about that, you can ask Mr. Lewis. All right, good luck to you, sir. Thank you. Thank you, Ms. Burch.
Excuse me, Judge. Mr. Garcia did want to address the court.
Okay.
Yo me siento apenado de todo esto, ¿verdad?
I'm extremely embarrassed for what I have done.
No supe actuar, hice las cosas mal.
I didn't know how to act.
Yo vine aquí a Estados Unidos a trabajar para ayudar a mi familia.
I came to the
Cometí un
US to
error
work and to help my family, and I made a huge mistake.
y le pido disculpas a todas las autoridades y a la persona que me demandó.
And I would like to ask for your forgiveness, Judge, and to everyone in the court, including the officers, and to the person that I committed this crime against.
The person that you committed the crime against is really the one
Dice la persona quien cometió el crimen.
that you owe an apology
Es a
to,
quien le debe más la
because
disculpa.
they gave you a job
Me
Porque le
siento-
dieron un trabajo.
and then you stole from them.
Igual
Y le robé.
Igual me siento apenado porque Estados Unidos me recibió acá para venir a trabajar y mi intención no es venir a hacer daño a Estados Unidos.
He said, I understand, Judge. I'm
extremely embarrassed because the US gave me an opportunity and I did not know how to take advantage of it.
Thank you, sir.
Gracias. Bye.
Justin Thomas, Mr. Lewis.
Yes, ma'am.
Good morning. Are you Justin Thomas? This is cause number 250308. I am going to take judicial notice of the court's file. Mr. Thomas was examined for competency to stand trial by Dr. Grapon. I received that report dated May 29th of 2025. The finding in that report is that Mr. Thomas is currently not competent to stand trial, and that inpatient treatment would be warranted for competency restoration. Is there any other evidence with regard to competency?
No evidence from the defense judge other than Mr. Thomas did want me to have it noted that he did not agree with Dr. Goupon's decision.
All right, thank you.
Not from the state.
All right, then, Mr. Thomas, at this time, based on that report by Dr. Grapon, I am going to find that you are not currently competent to stand trial. I'm going to order you to the appropriate facility for competency restoration for a period of not to exceed 120 days from the date you get to that facility. I would advise you to cooperate with any doctor's orders, medication, treatment, so that we can get you back here and get your case taken care of once you've regained competency. All right, you can go back with the bailiff. You just need to go back with the bailiff. Once you get competent, we'll take care of that.
All y'all would have to do is access the video yourself.
Okay.
He said I was one of the only persons that ever talked with a competency.
Okay.
With a competency. Oh.
Go home back with it.
I've been trying to say that, bro.
Trevante Ville. All right, so are you Trevante Ville?
No.
And in all of Mr. Ville's cases, I'm also going to take judicial notice of the court's files. Let me get one pulled up that has it. Mr. Ville was previously found not competent to stand trial, was sent for competency restoration. We have received, oh, that's not it. Here it is. All right, I've received a packet from the University of Texas Health Science Center John Dunn facility dated March 20th of 2025. That includes a trial competency evaluation report. In that report, it does show that Mr. Ville has attained competency while he was there. And is that all? Also, I received the attending physician's report for the letter to the court, and that was prepared by Dr. Nubia Liberis, also with the summary of the competency restoration and the opinion that Mr. Ville is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge.
Mr. Smith? Then at this time, based on that, I am going to find that Mr. Ville has achieved competency and is currently competent to stand trial. Mr. Lewis, will he waive the formal reading of the indictment in all of his cases?
He does, Judge.
And are we going on count one in all of them?
Yes, sir.
Mr. Ville, in clause number 24, DCCR 1933, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of harassment by a person in a correctional or detention facility from July 5th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? all going kind of slow. And then in cause number 24, DCCR 2061, the state has also elected to proceed on count one only. It alleges that you committed the third-degree felony offense of harassment by a person in a correctional or detention facility from August 20th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 25, DCCR 0025, the state has elected to proceed on count one only also. It alleges you committed the third-degree felony offense of harassment by a person in a correctional or detention facility from October 30th of 2024. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes, ma'am.
Clause number 242445, you're also charged in count one only with the third-degree felony offense of harassment by a person in a correctional or detention facility from October 9th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
And then finally, in cause number 241418, you're charged with the third-degree felony offense of attempt to commit assault on a peace officer from June 2nd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? In all of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them? I need you to answer out loud, please.
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
So if I follow the agreements, you can't change your mind later. Do you understand? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection, Judge.
It's admitted in each case. All right, Mr. Veal, I'm going to find in all of your cases, again, that you entered your pleas of guilty freely and voluntarily. Make that finding that you are mentally competent and that you understand the nature and the consequences of all of your pleas. Find sufficient evidence in each case to find you guilty. In cause number 241418, finds you guilty of attempt to commit assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 242445, finds you guilty of harassment by a person in a correctional or detention facility. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 250025 finds you guilty of harassment by a person in a correctional or detention facility. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 242061 finds you guilty of harassment by a person in a correctional or detention facility. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 241933, find you guilty of harassment by a person in a correctional or detention facility, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
File up here. No, it was Judge Pattison had this, so there aren't any notes.
Using the new system is not as easy, so I was hoping it would be.
I can share what it was, but I'm not trying to jump over it.
No, you're fine. So I want to make sure.
What's your understanding of the plea offer?
My notes, the last offer was possession with the intent to deliver. There would be no drug double and no supplement, and the prosecutor's office would recommend he be screened for adult drug treatment. Correct?
All right, the drug double makes a 20-year, a 40-year offense, and the habitual makes it a life offense. If it is reduced to a simple delivery, it would be a 20-year maximum offense. The guidelines would be scored based on that, and they would recommend your placement in local
Adult drug
adult
treatment
drug
court.
treatment court. Just I got sidetracked here. Do you understand, Mr. Tolbert?
Yes, sir.
If you have the preliminary examination a day, that offer would be withdrawn or revoked. I don't have a dog in this fight, but do you understand that?
Yes, sir.
All right. Spencer, he's joined me for sobriety court staffing.
Yes, sir.
This is the odd number Tuesday, but Judge Pattison is gone this week, so we aren't meeting today.
That's what I thought. Thank you.
We're doing a prelim if you want to get in on that.
No, thank you.
All right. Have a good week.
Thank you. You too. Happy 4th.
You too. All right. Okay, then I guess we're ready to go. Defendant declines plea offer.
Your Honor, people will call Deputy Jason Van Dyken.
Afternoon, sir. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Thank you. Please take a seat. State your first and last name and spelling for us.
Van Dyken, VANDYKEN.
Deputy Van Dyken, are you on the road patrol for the St. Joseph County Sheriff's Office?
Yes, ma'am.
And were you on duty on June 8th, 2025 of this year?
Yes, ma'am.
And around 12:40 p.m., did you have contact with a Burgess Tolbert?
Yes, ma'am.
Tell me how that came about.
While stopped at the light at Michigan Avenue and southbound 131, I observed a vehicle in my driver's side rear view mirror or side view mirror. After looking out the window as the vehicle approached a stoplight next to my vehicle, I observed the driver making a motion like this, indicating to me that he did not have a seatbelt on, placed a seatbelt on.
And so you were next to this vehicle?
Yes, ma'am.
Is this in Three Rivers?
Yes, ma'am.
All right, this is in St. Joseph County?
Yes, ma'am.
And what did you do after you saw the individual make that motion?
The light turned green. I positioned my patrol vehicle behind the vehicle that I observed the driver without a seatbelt on and conducted a traffic stop on the vehicle for such.
And as part of that traffic stop, did you come into contact with Mr. Tolbert?
Yes, ma'am. He was sitting in the front seat, passenger seat.
And the person that you identify as Burgess Tolbert, is he here in the courtroom today?
Yes, ma'am.
And can you point him out for the record?
He's the black male sitting to the left of Mr. Bush's right, my left.
Your Honor, may the record reflect he's identified the defendant.
It may.
And after making contact with the driver and Mr. Tolbert, what happened?
I gathered both of their driver's licenses, ran them through lien. Mr. Tolbert was found to have a warrant. He was taken into custody for his warrant.
When you took him into custody, did you transport him to the St. Joseph County Sheriff's Office?
Yes, ma'am.
And what happened when you got there?
After searching him on scene and not finding anything of evidentiary value, he was transported to the sheriff's office jail by myself. After arriving at the jail, he was removed from handcuffs by jail deputies and placed into the jail's receiving body scanner, which is located at the building.
And what is the body scanner used for at the jail?
It is used for the detection of anyone that may be smuggling illicit substances or items inside the jail that the jail determines or defines as contraband.
And did you observe anything unusual in the defendant's body scan?
Yes, ma'am.
What did you see?
After being alerted by the jail deputy that was utilizing the body scanner, he informed me that he would like for me to take a look at the screen. The screen depicts an X-ray similar to what you would see at a doctor's office of a human body that's X-rayed, but it's in the X-ray is over the entirety of a human body. Somewhere in or about the genital region of Mr. Tolbert, there appeared to be a bulging object that was clearly not part of his person, concealed again in or about his genital area.
And you've been a police officer for how long?
I graduated police academy in 2018.
And have you regularly done illegal narcotics investigations?
Yes, ma'am.
All right. Was there anything about this that struck you as unusual?
Not as far as narcotics investigations, no, because based off of my training and experience, I have commonly located contraband being concealed on or about the genital area of individuals that I have arrested.
Was he clothed when this scan was happening?
Yes, ma'am.
So after you identified what you believe to potentially be contraband, what happened?
I walked over to the body scanner while Mr. Tolbert was still sitting inside of it. And I asked or gave him an order to hand me the bag. Mr. Tolbert, acted as if he didn't understand what I was saying to him. And I reiterated my comment, give me the bag. I know that you have something on you or something to that effect. To which then he reached inside of his pants and produced a plastic baggie that later was identified to be containing methamphetamine.
And how do you know that it was methamphetamine?
It was tested for methamphetamine, if I do recall correctly. And during an interview with Mr. Tolbert, he stated to me that it was methamphetamine.
Do you recall how much there was and how it was packaged?
I believe it was approximately 1.61 ounces of methamphetamine. Packaged in 3 separate baggies that had product being methamphetamine in each one of the 3 baggies. Additionally, there were empty baggies of the same style, being a plastic baggie alongside of it. So it was one large bag with 3 individually packaged baggies of narcotics with empty plastic baggies alongside of it in the original bag.
And those empty baggies, were those like new or used?
They appeared to not have any sort of residual substance within them.
And based on your training and experience, what does this indicate as far as?
It indicates that the narcotics that were already packaged, to me, the empty baggies are generally to be used to package smaller amounts of narcotics to be sold at a later time.
And in your training experience, what is a user amount typically of methamphetamine?
Generally, users in my training.
Yeah, I guess he's not been qualified as an expert, but he's given expert testimony at this point. So I do think we need to call a halt to this and find out what his experience is.
All right, there's an objection, Ms. Davis.
Your Honor, he is a police officer, has been through the academy since 2018.
Why don't you just ask him a couple questions? I think he's probably got the expertise.
Could you describe to the court your training and experience regarding narcotics?
My training and experience regarding the narcotics would be while employed here at the sheriff's office, starting last year in July of 2024, I have over 20 narcotic seizures within a year. I believe that the experience of being able to detect and locate narcotics being concealed on individuals or within vehicles during my duty would give me reason to believe that I generally don't find more than 1 gram to 2 grams on any given person at any point in time who's not selling or does not have products or items that are commonly used for the sales of narcotics.
Do you do any continuing education training throughout the year?
When it's available.
And in those trainings, have you done any specific to narcotics?
Yes, ma'am.
And can you explain to the court kind of the background of those?
They're trainings that are given online that are mainly directed at areas of concealment on persons or vehicles that I have attended online in reference to the illegal transport or carrying of narcotics.
Your Honor, I believe that he has sufficient knowledge for giving expert testimony as a police officer with training experience in illegal narcotics.
I think so too. I think that Mr. Bush's objection was well timed, but I think you've established a record that this officer is qualified to testify about his knowledge of street user quantities of methamphetamine as a police officer investigator. So you may answer those questions.
Deputy Van Dyken, going back to this amount of methamphetamine and the manner in which it was packaged and the existence of other packaging materials, what would that lead you to believe as being a user or somebody who is potentially dealing?
Based off of my training and experience, the quantity of narcotics that were located on Mr. Tolbert is not generally a user amount. Based off my training and experience in contact with individuals who I have recovered narcotics from being concealed on their person who have openly admitted to me to being users. In those instances, those have never been in quantities above an ounce.
All right, so do you know how many grams there are in an ounce?
I would have to refer to my notes, but I have it written down in an area to where I have that documented as a cheat sheet for grams to ounces or grams to a quarter, half, or a third of an ounce. Something that I commonly refer to.
Is it somewhere like 27.7 grams or grams per ounce?
I would say that's close.
How much does a person typically consume if they're a regular user of methamphetamine?
It would depend on that person's daily or weekly use.
Minimum amount versus?
I would say there's no minimum amount. During my time as an officer, I would say that there are people who have admitted, not Mr. Tolbert, but people that I have had interactions with to using narcotics admit to me to use daily, bi-weekly, bi-monthly. It depends on how that individual is using narcotics.
And I'm sorry, how much at a time, like a gram at a time, or?
I would say less than a gram at a time, but perhaps it wouldn't be unusual for a user to use a gram throughout a 24-hour period.
Did Mr. Tolbert make any statements or admissions about why he was carrying this?
He admitted to me that he knew that it was methamphetamine and stated that he had been around it and claimed to me to be a user.
I don't believe I have any further questions at this time.
Mr. Bush?
Did the driver of the vehicle, was it determined to make any arrest on him for anything?
Can you ask that again, sir?
The driver of the vehicle, was it determined that he would be arrested for any violations as part of this investigation?
No, sir.
And did you have a partner that was with you during this stop?
No, sir. At one point, a trooper with the Michigan State Police showed up, but did not exit his vehicle or assist me at all.
So when you went to the vehicle, which side did you approach first?
Passenger's front door.
And why was it the passenger as opposed to the driver?
It's a common tactic that I use. If I'm along the highway, I normally step away from the flowing traffic that goes down a road. So it's not uncommon for me to still employ that tactic, even if it's in a parking lot.
So in your mind, that's a safety feature that keeps you off the highway then?
Generally, I'm farther away from the traffic that goes down the road, yes.
Did you search the general proximity around inside the vehicle of the defendant?
I asked for consent to search the vehicle and it was denied by the driver, which is his right to do so.
So was there a search completed incident to the arrest?
Of his person, yes. Of the vehicle, no.
Was the vehicle ever searched?
No.
Regarding his person, did you find any amounts of cash?
I don't recall.
If you would have found like $3,000, would you written that down?
I would imagine I wouldn't mistake or misplace or forget about $3,000.
But reason being, people are distributing drugs and they have cash. So did you find any cash?
No, not on his person.
Did you find on his person any scales?
No, sir.
Did you find any ledgers or notebooks keeping track of transactions?
No, sir.
And sometimes with narcotics transactions, there's multiple cell phones involved. How many cell phones or a cell phone did you locate on?
So it should be noted that upon demanding him out of the vehicle to place him in handcuffs for his warrant, I observed him actively take his phone and throw it back into the car to the driver, which the driver then recovered and remained in the car. I know that drug sales commonly are organized or orchestrated by the use of digital communications, cell phones, Facebook, Snapchat, or any sort of digital media or communication application that can be utilized on a cell phone.
Was there ever any follow-up to get that cell phone to see what?
It would have been one of the intended points and purposes of me asking for consent to search the vehicle, but ultimately the driver of the vehicle exercised his right to deny me consent to search the car.
Did you ask Mr. Tolbert if he'd used any drugs or narcotics recently?
During the traffic stop or during the traffic stop?
Well, so within 24 hours of when you came in contact with him, did you ask if he'd used any drugs or narcotics?
I don't recall.
And if somebody was to buy drugs illegally under the table on the streets, would they not be packaged in the form that you saw them?
Would they not not be
And
packaged.
would they be packaged in that form?
Well, one of the baggies of methamphetamine packaged was in a quantity that is less than an ounce, more than a gram. That is, in my training and experience, something that a user would purchase, yes.
Thank you. I have no further questions.
Thank you, Ms. Davis. Anything further on this witness?
No, Your Honor.
Thank you, Deputy Van Dyken. You can step down.
Thank you, Your Honor.
Any further evidence, Ms. Davis?
No, Your Honor.
Mr. Bush?
Defense question.
All right. Motions?
By the evidence presented by Deputy Van Dyken, I believe that the people have shown that there's probable cause to bind over on both the possession with intent to deliver controlled substance methamphetamine, as well as the possession of the methamphetamine itself. Mr. Tolbert admitted to the methamphetamine being what it was tested as such. As far as the packaging of it and the amount exceeding the regular user amounts, as well as his behavior of throwing his phone off of his person into the vehicle, which is in modern times where people are keeping track of their sales and making contact with people, as opposed to in the olden days having notebooks and ledgers. The defendant was identified by Deputy Van Dyken. He was a passenger in a traffic stop and he had a warrant. So he was searched to arrest. He then chose to not reveal that he had these items on him, and they were found by the body scanner and ultimately seized at the St. Joseph County Sheriff's Office. So with that, I would ask that he be bound over as charged.
Mr. Bush, your response?
Thank you. May I sit down?
Certainly.
I concede to the court that Ms. Davis has met her burden on count 2 on the possession of methamphetamine. I suggest to the court the issue today is what was in my client's mind. Did he have the intent to deliver those narcotics? A lot of typical things we expect with a drug dealer weren't there. Cash, scales, ledgers. Those are the things that we seem to deal with traditionally, show somebody to be involved in trafficking narcotics. My client admitted that they're his. He said it was for his personal use, and I would ask the court to not bind over on count 1.
All right, Mr. Tolbert, you're charged with, you're good, with possession with intent to deliver, which is the same as delivery, and then possession. Your lawyer concedes that the evidence shows you did possess it. The question here is whether you possessed it with intent to deliver, which enhances the punishment by double. As I told you before we started, this is a probable cause hearing. Now, there's certainly probable cause to believe that you did it. You were the only one there. There's no issue of identity here. Question is, did you have a deliverable quantity? 1.6 ounces. I wasn't clear whether that was just the product or product and packaging. But rule of thumb is about 28 ounces per 28 grams per ounce, actually a little more than that. But an ounce user quantities, there's more than enough for sale. Packaged separately in 3 separate smaller bags. Also unused bags or unresidue bags that could be used to repackage it. So there is probable cause. I'm not making a finding there's proof beyond a reasonable doubt. There's probable cause to bind this matter over to circuit court on both the possession and possession with intent to deliver. The drug double and the habitual simply go along with it. We don't need to make a finding on that here. You posted a substantial bond of $15,000 cash or surety. You've made all of your court proceedings. I'm about to lose jurisdiction over your case. It'll be transferred to the circuit court. We show an Albion address, but I know you were at some time a Three Rivers person. Where are you living right now, Mr. Tolbert? You're in Albion. All right. All right, as I said, you've made every court proceeding. You've been in contact with your lawyer. The plea offer in this case is revoked. Drug treatment court seemed like a good option, but I suppose a new plea agreement could be fashioned if the matter can't be resolved. If it can be resolved, you're entitled to have a trial. That'll be some time from now. The next step in the proceeding, the matter will be set for a status conference, probably not until several weeks from now, maybe September or even later. So stay in contact with your lawyer. I don't think he's on pretrial services.
I don't believe so, Your Honor. I would ask that the court, because there's been some question about the form that we've been using with bond, that the bond conditions reflect that he is not to violate any other law in the state of Michigan and not leave the state of Michigan without court approval. There's already the abstinence, not consuming alcohol or using any controlled substances except as directed by the doctor, and submitting to tests upon demand of any police officer. So I would ask that be not use or possess any of
Fair
those.
enough. I thought the bond form had those standard conditions, no other criminal activity and may not leave the state without permission, but nonetheless, those are the conditions. There's no allegation you've done those things. But the matter will be bound over to circuit court except for a status conference.
Thank you, Your Honor.
Mr. Tolbert, do you have any questions?
Yes, if you have any questions.
No, sir. No, you're good to go. Deborah, I did a bind over. I didn't get one in Slater. I couldn't print one, but here's this one. You can scan it in and then make sure we get it back. Both your clerks and my clerks are mad when we don't give them up the bind over. There's a fight over who gets it first. And as I said, I don't have one in Slater. You guys need a break? You ready to keep going? We're going been a half an hour. Let's talk to Mr. Slater. Why don't you come up, sir? Did you stop the record? Let's stop it, restart it. Good afternoon, sir. You're Don Jerome Slater? Yes, sir. Of course, I've met you, but I need to identify you for the record. Here with your lawyer, Mr. John Bush. Deborah, is this similar to the last situation regarding any plea offer?
Yes, double check. The offer at the preliminary examination was to reduce it to possession with intent to deliver cocaine and a possession of heroin, both as a third habitual.
You agree with that, Mr. Bush?
That was the offer that was on the table on the 24th.
And you decline that, Mr. Slater?
Yes, sir.
Well, let's make sure we're on the same page here. I had not seen this in a while, but you're charged with possession with intent to deliver less than 50 grams of cocaine. That's a felony punishable by up to 20 years in prison and a fine of up to $25,000. As a second habitual offender, makes it a 40-year, and as a fourth offender would make it a life offense. Count 2 is possession of heroin. Simple possession of heroin. That's a 4-year felony. I don't know how they came up with the schemes that they did, but possession of heroin is a 4-year, possession of methamphetamine is a 10-year. At any rate, that's also as a second or subsequent offense, which would make it an 8-year maximum, and habitual, I think, would make it up to life. So there's some serious charges. This is alleged to have occurred on March 24th. Once again, Deputy Van Dyken is our witness. Deborah, are you ready to proceed?
Yes, Your Honor.
All right, Mr. Van Dyken, will you retake the stand and I'll re-swear you again for this case. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Thank you. Would you state your name for the record, please?
Jason Van Dyken, VanDyken.
Deputy Van Dyken, are you a road patrol officer for the St. Joseph County Sheriff's Office?
Yes, ma'am.
And that's located in St. Joseph County, Michigan?
Yes, ma'am.
Were you on duty on March 24th of 2025?
Yes, ma'am.
And in Lockport Township of St. Joseph County, did you come into contact with a Don Slater?
Yes, ma'am.
Do you recall what time it was of day?
It was in the earlier morning hours.
And tell the court how you came into contact with Mr. Slater.
While on just patrol within the county, traveling on South River Road, I pulled into the boat launch at Stump Bay, which is off of the St. Joseph River. I observed a vehicle solely backed in, a sole vehicle in the parking lot of the boat launch, backed in. Couldn't readily observe anyone inside of the vehicle. And at that point in time, made a citizen's contact with the vehicle.
And what type of vehicle was this?
It was a black Dodge Charger.
And did it have any boat or sort of watercraft trailer attached to it?
No, ma'am.
Okay.
Let me stop you for a minute. I'm not clear on the time frame here. You said early. What time were we talking about?
I would say after the sun rose, but before 11 o'clock in the morning, mid-morning.
Okay.
And Deputy Van Dyken, does the time 9:47 a.m. sound accurate?
Yes, ma'am.
And you would have indicated that in your written report, correct?
Yes, ma'am.
Okay. How did you make contact with Mr. Slater then?
I approached the vehicle, and I don't recall if I called out to the vehicle or observed somebody inside or tapped on the window, but I approached the vehicle and later got into contact with Mr. Slater.
And the person that was in that vehicle, what part of the vehicle was he in?
The driver's seat.
And was he awake or asleep?
I couldn't tell at the point in time that I made contact. But if I recall correctly, when the door opened up, the seat was leaned back and Mr. Slater was seated in the front driver's seat of the vehicle.
And was he the only person?
Yes, ma'am.
And the person that you saw in the driver's seat that identified as Don Slater, is he here in the courtroom today?
Yes, ma'am.
And can you point him out for the record, please?
He's the black male seated to the right of Mr. Bush, my left, wearing a camouflage vest and white t-shirt.
Your Honor, may the record reflect he's identified the defendant?
Yes, it may.
When you made contact with Mr. Slater, what happened?
I had a general conversation with him, inquired as to what he was doing. He had stated or made a comment to the effect of I was just waiting to be picked up. At which point in time I asked for his identification just to confirm to whom I was speaking with.
And when you got his identification, did you run his name in
Yes,
lien?
ma'am.
And what did you find?
It showed that it had a warrant for his arrest out of Kalamazoo County. I then asked for him to step out of the vehicle and detained him at that point in time, awaiting for further instructions as if Kalamazoo County wanted him lodged or held on those warrants.
And was he aware that he had a warrant?
I don't recall.
Did you end up doing a search of the vehicle?
Yes, ma'am.
And what brought about that search?
I had asked while Mr. Slater was in the backseat of my patrol vehicle if he had any prior contacts with law enforcement or history with law enforcement, which he had stated yes, and indicated to me that he had prior involvements with law enforcement in reference to crack cocaine. I then asked for his consent to search the vehicle that he was found in, and he granted me consent to do so. Furthermore, with myself at this point in time being the only deputy on scene, I did indicate to Mr. Slater that if he were to need anything from myself, that I would roll the back window down. So that way, if he called for help or rescinded his consent, I would be able to willfully and actively hear him do so while I was away from my car.
So it's your testimony, it was a consent
Yes, ma'am.
granted search. Okay. And as part of searching the vehicle, did you find anything of evidentiary value?
Items of evidentiary value were located in the vehicle, but not by myself.
Okay. And after the items were located, did you send them to a lab?
Yes, ma'am.
Okay. Did you get lab results back?
Yes, ma'am.
And what were the results of the items that were found?
Analysis on 2 items sent to the lab were found to be heroin and cocaine.
And is it accurate that the Michigan State Police laboratory report indicates that the one item was cocaine by itself and that the other was heroin, fentanyl, and cocaine with
Yes,
another mixture?
Yes, ma'am.
Okay. How were these items that were found during the search packaged when you?
There was
aware of
one baggie concealing all of the aforementioned items inside of it.
And who found this?
Deputy Miller did.
And that would be Deputy Travis Miller?
Yes, ma'am.
And what in your training experience leads you to believe that this individual was involved in the possession with intent to deliver?
You probably do need to make a record. Granted, we just went through this a few moments ago.
Yeah, but it's a separate record,
It's
I
separate.
understand.
Sure.
We have the same issue we had last time. Apparently the officer does have some expertise in this area, but we don't have any of it in Mr. Slater's record, so. I'll
Sure.
ask you to inquire once again.
Deputy Van Dyken, how long have you been a police officer?
Since 2018.
And as part of your training, did you do any training regarding narcotics,
Yes, ma'am.
sales, packaging, and identifying when it is a user amount versus something that might be for sale or delivery?
I've received that training through the discharge of my duty and prior seizures of narcotics, yes.
And have you been on the road patrol with the St. Joseph County Sheriff's Office for a period of time?
Since July of last year.
And since you've been on the road patrol, have you come into contact with a number of narcotics users and delivery and sales?
Yes, ma'am.
You already believe that establishes?
I think he said in the early case, he's made 20 seizures in the last year. That's
Approximately 20 seizures within a year on the road patrol here at St. Joseph County Sheriff's Office, Your Honor.
All right, I believe for purposes at least of the preliminary examination, it qualifies as an expert testifying about street and law enforcement and of narcotics packaging, use and delivery.
Thank you. Deputy Van Dyken, can you explain how these items were packaged?
The heroin was packaged individually by itself in a cellophane style or plastic baggie style packaging material, which is common to me based off my training and experience that narcotics are concealed in for transport, sales, use, or otherwise.
Let me stop you because there's a difference between cellophane, which is a wrap, or a baggie.
A baggie of a plastic material.
All right, well, how big were the baggies? Sandwich size or the smaller size?
The baggies on the crack cocaine, I couldn't tell you if it was from a sandwich baggie or a gallon size baggie, as the plastic itself was tight to the rock. So if you could imagine placing it inside of the corner of a bag, or if it was a loose bag that doesn't have a corner, pulling a knot, the plastic knot down to the rock tight enough to where you pull the rest of the bag off, and you physically have a rock that is tightly
So
contained.
it was
in
just
plastic.
a corner of a baggie.
You could say that, yes, Your Honor.
How many of those small corner baggies, rocks were packaged separately?
I would have to refer to my report to give an exact number, but I believe there were to be over 4 individual pieces of crack cocaine.
Your Honor, actually, Deputy Van Dyke, would it refresh your memory if you were able to look at your report?
Yes, ma'am.
Your Honor, may he look at his report?
Yes, he may.
Do you remember being refreshed?
Yes, ma'am.
All right, how many baggies individually were there?
Approximately 9 baggies of crack cocaine.
And those 9 small ripped off corners were in one larger bag?
So the bag in and of itself that was located was concealing the crack cocaine and the heroin alongside of it. The heroin and the crack cocaine within this baggie that I am describing were individually packaged inside of the original bag that was containing it.
And based on the quantity of those and the amount in each of them, what did that indicate to you?
That the individual, being Mr. Slater, who was in possession of the aforementioned narcotics, was possessing them with the intent for them to be sold.
When you say approximately 9, is there some reason why we don't know exactly how many there are?
No, Your Honor, it's just the way that it was listed in my report.
All right, so I guess we'll just leave it at that. Maybe the state police counted them as part of their report. Right.
Did Mr. Slater make any admissions about these items belonging to him?
I believe, if I recall correctly, he stated that the crack was his and that he was a user.
And whose vehicle was this?
The vehicle was not registered in his name, and I believe that he had stated that it was his girlfriend's car.
This isn't the car that was in the accident, is it? It was a Dodge Charger.
No, I think that was different. There's a lot of Dodge Chargers in the county. No, I don't believe this is the same one. I don't believe I have any further questions.
Well, what about the heroin? I am not understanding how that's packaged.
Sure. Can you describe?
That would be in something that you could call a corner baggie, Your Honor. So the heroin was packaged in its own independent bag. The crack cocaine were packaged individually. And if you were to pick those items up in your hand and place them in a bag and then conceal that bag that was initially was found was concealing a bag of heroin and approximately 9 crack rocks.
Right. So approximately 9 baggies of crack cocaine and then another baggie of another substance, which apparently tested to be heroin, fentanyl, and cocaine.
Yes, Your Honor.
Which is a Death Star type thing. All right. Were these weighed at any point?
The Michigan State Police Laboratory analysis report would have a controlled setting weight for these items. I believe they remove them from their packaging and get an honest, accurate weight from their scales that are accurate at the lab.
Mr. Slater, there's a special rule for preliminary examinations that the prosecutor can produce the laboratory reports just for the prelim. If it was a trial, they'd have to have the person here that tested it and established a chain of evidence. But just for the prelim, they can submit the reports and the court can consider them. Ms. Davis, are you going to put those lab reports into evidence?
I do have one lab report. It was provided to the defense, and I can certainly email it as an exhibit to the court. Don't have a paper copy of it, but I can get one.
I have a hard copy of it with that to speed up the process.
Sure, as far as that goes, I mean, if the defense is willing to stipulate to the
All right,
weight
Phil.
on it.
Yes, under the court rule, just for prelim only, yes, if you'd submit that, so I can
Sure.
consider that.
And Deputy Van Dyken, the Michigan State Police Lab did complete the testing of these items, correct?
Yes, ma'am.
And that was done by Jerome Waldron, a forensic scientist. Is that your recollection?
Yes, ma'am.
And you received a copy of this report and submitted it to the prosecutor's office as part of your investigation?
Yes, it would have attached to case file.
All right. I did send via email the proposed exhibit number 1, which is the Michigan State Police lab results regarding this matter.
Takes a long time to get from there.
Apparently, hopefully
There it
it's
is.
getting there soon.
All right, by stipulation, at least for prelim purposes only, I'll accept the laboratory report. It's dated April 25th, 2025, under the signature of Jerome, Jerome Waldron, Waldron. Thank you.
Deputy Van Dyken, on that report, it indicates that item number 1, which was one of the knotted baggies of cocaine, weighed 0.3077 grams. Is that your recollection?
Yes, ma'am.
And so is that just one of the 9?
That would be one of the 9 individually packaged pieces of cocaine or crack cocaine, yes.
And do you know like a usable amount or how much one
That
would
would,
consume?
in my training and experience, commonly be what a user would purchase to smoke in a crack pipe.
Like one, I don't know how to say it, one serving, one,
To whatever you would want to describe it as, but that would be what someone would use as or purchase as a user amount of crack cocaine.
okay. And the other item, number 2, is listed as 0.7525 grams of the heroin, fentanyl, cocaine, and ANPP mixture. And do you know anything about the user amount of that
So,
material?
Based off of my training and experience in prior contacts and cases when I have seized heroin, I know that heroin is commonly packaged in what's called a bickle, commonly a folded piece of paper, not any sort of paper in particular, is folded up in a small manner. And bindles of heroin, in my training and experience and knowledge, are commonly packaged in 1/10 to 1/8 of a gram of heroin. And that is what users of heroin commonly purchase.
And so this would be like 7 times. the
I
amount of a
mean,
user?
if it's a straight 7.0, then that would be, my basic understanding of math would be correct, 7/10 of a gram.
Is there anything else about this particular situation that led you to believe this was more than just a user amount?
I know that individuals who use narcotics based off of previous interviews and cases with the seizure of narcotics from users, I know them to not commonly use more than one drug substance at a time.
Of these type of substances or in general?
In general, so during questioning in a case in reference to narcotics, if I were to have found, let's say, a gram of methamphetamine concealed in someone's vehicle, it would not be uncommon for me to ask that individual in this circumstance, what's your drug of choice? Generally, they openly admit or before they know that I have seized narcotics from their vehicle or person or otherwise, their answer is generally never anything other than it's meth or it's heroin or it's cocaine. Generally, in my training and experience in my duties on patrol, I don't commonly come across individuals who openly admit to be using multiple drug types or drug substances at any given point in time or alongside one another.
And so the numerous amounts of crack cocaine and then the other item having heroin, fentanyl, and cocaine, that did not strike you as something that this individual would be using in the same timeframe? No further questions.
All right, Mr. Bush, you may cross-examine. Thank you. Just to know, Mr. Bush had some serious leg injury and surgery, and as a consequence, I'm allowed to just ask the questions from being seated. He's still having mobility issues.
Thank you, Judge. The cocaine, the 0.3 grams, you say that's a typical daily usable amount?
That would be something that I wouldn't find to be abnormal that a user of cocaine could purchase for use.
And if there were 7 or 8 of those packages, that would be about a week's worth then?
I don't know. I don't personally use narcotics myself.
Well, you did say that you use 0.3 a day, and if there were 7 of those, could that be a week's worth?
It could, but I would say that that would be independent to that individual user who's actively using crack cocaine.
And the heroin, fentanyl, and cocaine mixture, was that all of it, or was that just a portion of what was seized that was weighed?
What, can you ask the question again?
The heroin, fentanyl, cocaine mixture,
Okay.
was the 0.725 grams, was that all of that, or was that a portion of it?
I don't know. I was not the individual that tested that baggie of narcotics at the lab, but upon its seizure, that mixture was contained independently in its own corner baggie.
So in all likelihood, that is the total amount of that drug.
Yes, sir.
Talk a little bit about that time that we came across the defendant. Was the vehicle legally parked?
Yes, sir.
And was there any signage in the boat launch park that limited hours or when you could be there?
There are, however, he was there inside of the allotted amount of time that people have to occupy the boat launch.
And I'm assuming that as a good road officer, you probably ran the plate when you saw it?
Yes, sir.
Was it validly registered?
If I recall, it was.
And was there insurance on the vehicle?
I do not recall that.
Was there any be on the lookouts or anything for nefarious activity that was going on in that boat launch at that time of that day?
No, sir.
And I'm not sure how much boats are launched on the 24th of March, but do you get around that boat launch much?
I'm through there frequently, yes.
In that week, was there activity of boats being launched in and out?
I don't recall.
Is this boat launch known as a place where people congregate for exchanging drugs?
I would say that it's a location that is seldom used unless you're there for fishing or otherwise. In my experience on patrol here at the sheriff's office, I have come into contact with multiple people that are there utilizing it for other reasons other than fishing or launching a boat.
I guess I'll just leave it at that. Thank you.
You're welcome, Your Honor.
And if I understand your testimony, there were no other vehicles in that boat launch area, was that?
That's correct, sir.
And in your personal experience, were you familiar with Mr. Slater's vehicle?
I don't believe that I have actively seen it or ran the plate before, and if I have seen it, it's nothing that I've actively pursued or investigated or anything of that nature. I work in the county, and it seems as though Mr. Slater lives in the county, so it's not outside of the realm of possibility that I passed the car, but I've not actively investigated that vehicle per se.
And you and a fellow officer were involved in searching the vehicle, is that correct?
Yes, sir.
And are you familiar with what was located in the vehicle, or are we going to hear that from the next witness? Or-
Am I familiar with it? Yes, it was turned over to me as evidence.
Okay. Then I can ask these questions. Were there any digital scales or scales located?
I don't recall.
Obviously, if they were there, you would put that in.
Absolutely, they would have been seized, yes.
Any out of the ordinary amounts of cash located?
There was a quantity of US currency that was on Mr. Slater's person. However, I did not seize this as evidence or seize it for civil forfeiture. It remained on his person up until the point that he was turned over to the custody of Kalamazoo County Sheriff's Office deputy in Schoolcraft, Michigan, for him to be lodged at their facility.
Can you share with us what that amount was?
Less than $1,000, but more than 100, in between $100 to $1,000.
Were there any ledgers, paperwork, documents?
No, sir.
Did he have cell phone or cell phone?
He did have a cell phone, yes.
What happened to that?
It remained with him while he was turned over to Kalamazoo County Sheriff's Office.
So it was never forensically searched then?
No, sir.
I didn't ask this in the last case, but I'll ask it here. Do you recall what the warrant was for?
I believe it was for child support, Your Honor.
Thank you.
What piqued your attention to go up to Mr. Slater's vehicle?
It wouldn't be uncommon for me to do that with any vehicle that's parked there. As I exited my patrol vehicle and walked towards it, I noticed an individual that I could partially see or obscured inside of the vehicle. And just to check on his well-being, as it appeared the seat was leaned back. It wouldn't be uncommon for members or agents of law enforcement to find people being overdosed from narcotics in a public area or have harmed or killed themselves in a public area that's not out of the ordinary. As well as occupying a public space, I have the right to make a citizen's contact with any member of the public that's also occupying the same public space.
I have no further questions.
Any further?
Just briefly,
where in the vehicle were the narcotics found?
They were located within the dash, being concealed inside of the vehicle. These, again, items were seized or found by Deputy Miller, later turned over to myself. It should be noted that when I was originally searching the vehicle, based on my training and experience, I know that individuals who conceal for use or conceal for sale items of narcotics or otherwise commonly use natural void spaces within vehicles to obscure their narcotics. While I was searching the vehicle with two outstretched rigid fingers, I could run my fingers in between a portion of the trim work of the dash and use little to no effort or power to drop that trim work of the dash down, indicating to me that the vehicle in and of itself was no longer in its current manufactured condition, indicating to me that the vehicle or that portion of the vehicle had been routinely manipulated, because the disassembly of modern vehicles requires either a skill set or knowledge of how to disassemble that vehicle or tools to remove that vehicle if it's never been tampered with before.
No further questions.
Anything further?
No follow-up.
Thank you. You can step down.
Thank you, Your Honor.
We should call your next witness.
Yes, the people will call Deputy Travis Miller.
Good afternoon, sir. You swear or affirm that the testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Thank you. Please have a seat. State your name for the record.
Travis Miller,
Would you spell your last name, please?
Miller.
And Deputy Miller, are you employed with the road patrol of the St. Joseph County Sheriff's Office?
Yes, ma'am.
And were you on duty on March 24th of 2025?
Yes, ma'am.
Did you assist Deputy Jason Van Dyken with a traffic or contact with somebody in a vehicle in Lockport Township?
Yes, ma'am.
And tell me what your involvement was, please.
I arrived on scene due to Deputy Van Dyken's extended time on his call. I want to make sure he was all right. So I made contact Deputy Van Dyken. At that point, he was about to search the vehicle. I asked him if he had consent. He said he did. At that time, he directed me to the driver's seat area of the vehicle, where he had stated that the paneling underneath the steering wheel had been tampered with and easily removed. While he continued to search the vehicle, I then focused my area on the natural void spaces below the dash.
And what did you find?
I located a plastic baggie, which in my training experience appeared to be narcotics.
And can you describe exactly where that was?
In the Dodge Charger, directly underneath the steering column, there is a small gap of a natural void space, which could easily slip items of contraband in, and it fell on a metal bracket below that, so it was very concealed. I had to get underneath the dash, and I saw the tip of a corner baggie, and upon pulling it out behind the dash, it revealed a larger baggie of narcotics.
Did that take up the entire space, or how big was the package of narcotics in relation to the voided space that was available?
I would say it filled the space it was in, but the area it was in was a tighter concealed natural void in relative to the larger void of the paneling that had been removed.
So could you fit more under there if you wanted to?
I'm sure you could fit more.
Okay. What did you do with this item after you discovered it?
Upon taking it out of the vehicle, I immediately turned it over to Deputy Van Dyke.
All right, did you have any further involvement with this? No further questions.
Mr. Bush?
Deputy Miller, did you locate anything else related to drug trafficking, drug trade, drug use?
I don't believe there's anything else of evidentiary value located in the vehicle.
Did you look anywhere else, or was it just really just that underneath the dash that you searched?
I assisted Deputy Van Dyke with the rest of the vehicle, but I did not thoroughly search the rest of the vehicle.
What do you mean by that?
We searched the same general areas. I did not dive deep into the I mainly focused on the driver's area where the natural void spaces were.
Was the vehicle cluttered with a lot of material objects in the vehicle?
There were personal effects of clothes and such in the trunk. But nothing, it wasn't cluttered full.
Thank you. I have no further questions.
Thank you, Mr. Down. Any further, Ms. Davis?
No, Your Honor.
I've heard the testimony of two witnesses, and I've admitted the laboratory report as exhibit 1. Mr. Bush, you have anything further?
Thanks, Mr. Chairman.
Motion?
No, I believe that people, after the testimony of the two deputies, have established probable cause that Mr. Slater was in Lockport Township in St. Joseph County, Michigan on March 24th of 25, and that he had in his possession an amount of cocaine, crack cocaine, and heroin mixed with cocaine and fentanyl that is consistent with what could be a dealer or seller level, which would indicate a possession with the intent to deliver those items, in addition to the charge of just possessing those. It was a consent search. There was nothing unusual about that other than the voided space. It's typical that if you give a consent search, it's usually because you don't think they're going to find anything. And when there's a voided space, it would indicate that you were trying to conceal those while still giving that consent search. But they were ultimately found, and with the amount that was there and the type of drugs, as the testimony indicated, I would ask that he be bound over as charged.
Mr. Bush?
I would object to the motion, point out to the court that the vehicle apparently did not belong to Mr. Slater. That's the first argument I've made. Second argument would be with respect to the intent to deliver on the cocaine. I think it's fairly clear that there was about maybe 7 days worth of cocaine there. It's not an exorbitant amount for somebody to have personal use. So I would ask the court not to bind over on the possession with the intent to deliver charge.
All right, thank you. It is an interesting defense that this isn't his vehicle. But he was there, he was in close proximity of it. Again, Mr. Slater, the standard here is probable cause, not beyond a reasonable doubt. We got the state police laboratory does report confirms there were 9 knotted packages. They weighed 1, which was 377 grams. A third of a gram. There were 9 of those, which if they're all the same size would be 3 grams, which is exorbitant, but they're packaged separately. The other one, 7 grams of fentanyl, cocaine, and heroin. That's a good way to wake up dead. I don't know what the other stuff is. Phenylphenylpiperidine, ANPP. It's a Schedule 2 substance. I'm not sure what it is. I don't know that I want to ingest that. At any rate, for probable cause purposes, again, Mr. Slater, similar to Mr. Talbert, I find there is sufficient probable cause to find on both of these matters. Each are close. You have an additional issue of this wasn't your vehicle. You did admit to being a crack cocaine user. And I'll bind the matter to circuit court. Similar to Mr. Talbert, I think your bond conditions are very close to his. You've also posted a surety bond. You've always, to my knowledge, made every court appearance. And so your bond will be continued. Let's talk about your bond conditions. I expect they're very similar to the last ones.
It appears in this one, they did recommend pretrial supervision.
So are you meeting with the ladies from Community Corrections?
Yes, I just check in once a week. I check in every week.
Then just keep doing what you're doing. Now, you are a Three Rivers guy. You were on South River Road, but is that how, are you still at that house?
No, sir.
But are you still in Three Rivers?
No, I gave my attorney the address. I'm in Ben Harbor.
Okay. All right, again, you don't have to live in St. Joe County. You can't leave the state without consent. Or you certainly can't commit any other crimes, but if you have something you have to go to, you can ask to amend your bond. In the meantime, both of these matters are bound over to circuit court. Status conference will probably be set. These are going to go through right at about the same time with the same lawyer. So yeah, I bet your next court date will be on the same day, probably sometime in September. Anyway, you've met all your bond requirements as far as my court is concerned. You're free to go, sir.
Your Honor, I did email you.
I saw that. I'll print it and I'll sign it. I'll also print out that exhibit and make it part of the file.
Thank you.
All right, we did that in an hour and 15 minutes. That completes our day. Hope Judge Patterson's enjoying fishing or whatever he's done. And we'll be back in the morning.
Do you like transcripts?
Please. So I don't need to send you them.
No. I figured you guys just want to get verbal confirmation.
All right, we will stop our live stream and give our visitors time to make it home by